a slight grin. Picks apart the cases where the truth's been thin. Sharp tongue firing like a rebel's hell. Justice served with a snarky spin. Nick's got the mic and is breaking it down. Lego chaos spinning all around. Laughing at the lies at the courts of crown. Riding the edge where truth is found. Coffee's cold but the witch stays hot. Poking at the holes in the legal plot. With a tilt of the glass he connects the dots. The courtroom's wild and he calls the shots. Nick's got the mic and is breaking it down. Lego chaos spinning all around. Laughing at the lies at the courts of crown. Riding the edge where truth is found. Electric strums echo through the air. Justice tangled in a legal snare. With a grin, he tears it bare. No nonsense talk for those who care.
Hey, oh, damn, that ended quick. Hi, hey, oh, and welcome to It Is Tuesday. It is Tuesday, right? It's Tuesday. It's my week off. Today, they didn't call me because they my employer, or well, the union didn't call me in for something today because they discovered when they called me in yesterday, they had to give back 2 vacation days instead of the one they took away from me. And which would mean that in the fall or winter, I could take an extra day off. And yeah, they don't want that too often. When you're needed, you're needed. When you're needed, you're needed. Hi, Jean. Says, I need to research this case, but I have a feeling it was more fire than a bomb. Yes. Well, it was a fire in a contained chamber, and it went a bit kaboom. Oh. So, yeah, a brief synopsis of this case. The parents of Thomas Cooper, 5 years old, had ADD and sleep apnea. And according to some interesting research, hyperbaric chamber treatment is supposed to do some help with that. Now, it's not approved, it's not covered by insurance, and it has the trademark of there are very many desperate parents and people out there where conventional methods doesn't seem to help, and then they search for alternative methods, and hyperbaric chamber treatment is one of these. So Thomas, 5-year-old, was in treatment in Michigan at this place. He was put in the chamber. The chamber was filled with 100% oxygen and was then pressurized. When pressurized, it means that oxygen every direction. You breathe in 100% oxygen, everything, it's in your lungs everywhere. And then a spark. And 100% oxygen is extremely flammable. So the hyperbaric chamber burst into flames, covering Thomas with fire. The mother tried to save him, reached into this chamber to pull him out of there, late sadly, which also caused burns on the mother of Thomas. And after this, an investigation took place, and according to the prosecution, the maintenance was extremely flawed on this hyperbaric chamber. For instance, the manufacturer of these chambers say every 22,000 cycles it has to be maintained, it has to be serviced. And according to the prosecution, somebody mixed with the numbers. And that 22,000 was reached in 2022, according to the state. So from 2022 to this spring, to February, it has been solely maintained and serviced by employees. And as if you go back, I have a video out on the initial hearing where they claim that, among other things, the grounding cable was not attached, which means if there is a buildup of static energy, there will be a spark sooner or later. Mispronounced name. Was the hyperbaric treatment for the ADD or for the sleep apnea, or both? It seems like both. Now, I can see sleep apnea, because sleep apnea is the condition where you stop breathing as you sleep for a short period of time or even a longer period of time. So you have to, in severe cases, you get this mask that pressurizes and breathes for you. So it forces you to breathe. And hyperbaric means pressure is, or they put pressure, 100% oxygen, pressurized, and it's supposed to open up things. ADD, I don't know. I honestly don't know. I've tried to read up on the so-called there are some studies out there that is about something about, what was it? Increasing blood flow, opening up some vessels in your brain. Yeah, it seems like a circular argument. If this could help, then this could be a treatment, then that should happen, and that it's I don't know, but this is a treatment that, as I said, insurance doesn't cover it. It's not approved as a treatment, which means that people have to cough up the cost for them by themselves. And this seems to be a very lucrative business, because the CEO, Tamala Peterson, has several of these plants, or what you should call it, facilities, both in Michigan and in other states. So it seems very lucrative. And but this time, well, to put it frankly, that chamber, what happened, since 100% oxygen pressurized, he was burnt from the outside and from the inside, because there was 100% oxygen in his lungs. That poor kid had no chance. I have one video and one stream I will link that in the commentary section after this stream, where you can find those. It also has a playlist where you can find what I've done on this case so far. I had Dave on last time because he's a Michigan-based attorney, and this case will take some time before it goes to trial, if it goes to trial. And I don't see it be brought to trial until late 2026, and Dave guessed early 2027. So it will take some time, but so this is one of these cases I will cover from gavel to gavel. If there is a new hearing, I will cover it. If there is a development, I will cover it. If it goes to trial, I will cover it from gavel to gavel. Yes, Cal here says, scary thing is she still has another place that's up and running doing the same thing. She has several places. Several. In and out of Michigan. Turnips, does criminal have to complete before civil? Not necessarily, but it would be, I assume, for the sake of, because if they are convicted, any one of them, because it's the CEO and 3 employees, if any of them are convicted, the civil case becomes that much stronger. I assume they will have a civil case going already, because since it's been a very lucrative business with facilities all over the place, there's, sadly, the civil cases, it's about compensation, it's about money, it's about making sure this will never happen again in other places. Because if they fuck up, it will cost them everything. The people responsible. In this case, it's Tamala and what's the name of them? Yeah, I will catch up on that. Hi, Marcia. Hello, Rick. Watching for Virginia. And Siobhan is here. Daily Quick Bites. Hey, Daily. Hey, Daily. Good to see you. Daily says it's important to note that it's fortunate the containment vessel held. Looking at the size of the vessel, it could have killed lots of people had it failed. Yeah, if it actually blew up, everybody in that room would have been, because it's more or less not a glass container, but what do you call it? Safety plastic something. And the shards from that, if that shot out, yeah, it would have ended everybody in that room. So yeah, negligence issue. Yeah, plexiglass. Thank you. That was the word I was looking for. Due to this, it's a negligence issue. Negligence, and also the claim is that the mishandling with the maintenance, with the service, the argument here from the state is it was on the order of the CEO to cut costs, to make more money. So that would mean that it was an active decision. Now, it wasn't an active decision to just this kid, but it was an active decision nonetheless, which brings it to murder 2. So all 4 defendants are charged with murder 2, and lesser included. And Tamala, her bond was $2 million. And she posted it. So she's at home awaiting trial. Everybody, and then the other employees got, I believe, $200,000. And I think all of them were able to post bond. But the bond conditions is something we brought. There was a bond condition hearing in the previous stream I did about this, where one of them complained about it was too narrow because he couldn't even go get his mail. So, Yeah, I mean, what can you say? He's at home, at least. Yeah, he might be bored, but he can still go to place of work. It was concluded that it was a bit vagueness in the original order, so now he can go to church and other things. So he's not in jail. He's at home. He might be bored, but I mean, that's better than a majority of people being charged with a crime of this severity. Hey, yo. Nick, did you hear about there was a therapist that died in a hyperbaric oxygen chamber in Arizona because it's caught fire? Yes. Once we're done with this new hearing, I will go through that case. I have an article prepared for that one. So we will go through that one as well. And once we are done with that, there might be hearings today that are scheduled that I have interest in. And let's see here. I don't know if it started yet. I don't think it started yet. It hasn't started yet. Yeah. So we will have, I mean, at least, once we get through this hyperbaric chamber explosion case and the one in Arizona, we will jump onto other hearings or documents that has been posted lately. So we will be here for a while. So thank you for being here, and hope you will enjoy. Well, I hope I can bring information to you and explanations and some snark. Now, this hyperbaric chamber case, it's hard to get snark into it because it's so tragic. But I will do my best. So, with that said, this is the CEO of Oakland County Facility, the Hyperbaric Chamber. She is the one that is ultimately responsible that everything in that facility worked. And it didn't. Okay, let's get this one up. And let's go.
All right. Court is now in session. Honorable Morning Municipal Society. Thank you. You can be seated.
Just something.
Now calling 250000876, the people of the state of Michigan versus Tamla Peterson.
Thank you. Good morning, Your Honor. Assistant Attorney General Chris Kessel for the people.
Good morning, Your Honor. Joe Gleason on behalf of Tamla Peterson, who's seated to my left.
Thank you. Could you stand and state your name?
Tamla Peterson.
Thank you. Are you still using the same address that I have for you in the court file?
Yes.
Thank you. Today is the date and time we had scheduled motion that was filed on behalf of the defendant. It was a motion requesting an evidentiary hearing to determine the extent of law enforcement's access and review of privileged materials. I've obviously reviewed the motion. We had a response that came in last week. So where do we stand?
Your Honor, I may just add a couple brief comments in addition to the motion, because obviously the reports that were attached were not available at the time I filed the motion.
Of course.
Thank you. Your Honor, what I'm asking for, and I know the court is aware of it, is an evidentiary hearing to determine what the police looked at when they examined the computers and telephone of Ms. Peterson. At the time I filed my motion, I was aware that the detectives from the Detroit Police Department had done an investigation because they told the magistrate when they did the swear-to and the bond hearing that they had revealed, and I believe the Attorney General made some comments as well, that they had located information that they used to persuade the magistrate, among other things, to set a very high bond. There were a very limited amount of reports at the time indicating that at least they had looked at things, but not the nature of the searches, how they had located them, anything that really documented the searching that went on. Ms. Peterson had attorneys prior to February, I believe 5th, when the items were seized. They had been longstanding attorneys. I notified the Troy Police Department when the items were seized, saying, look, we're the lawyers. You shouldn't look at our attorney-client privileged materials. And at least at the time of the filing of my motion, there were not the reports that the court received from the Attorney General. And that causes me some concern, because these reports are generated 6 months after the searches took place. These reports are dated July and late June of this year, when the searching apparently occurred in February. And I'm not sure why these reports are being generated now, when they should have been generated at the time the searches were made. And even so, what's been given to the court and to me in these reports is fairly, I would say, lukewarm at best. They don't identify, especially when I see a Detective Mork's report, what items he looked at specifically, what searches he used, i.e. how he framed his searches, whether in fact he actually looked at the 75 records that he bookmarked as communications between Ms. Peterson and a member of the Varnum firm. And so these appear to be kind of stopgap reports that are of a very general nature as to what exactly occurred. Now, I don't know what occurred. I have not been provided any detail about the searching, but I'm extremely concerned that this was withheld from us in February or March. And Mr. Kessel, to his credit, I said, Mr. Kessel, where are these reports that generated this information that you used at the bond hearing and that Detective Trigger mentioned at the swear-to? And the first thing I get back is an email saying, well, 8 detectives from the Troy Police Department examined these devices. I didn't know that, because the materials I got originally from the Troy Police Department didn't talk about 8 detectives looking at forensic examinations of electronic devices. Then, after being told that these detectives look at this, I get these reports generated 6 months later. And
Now, reports generated 6 months later. Now, this, if you remember, the other cases I've been covering lately, the Brian Walsh, where reports are being done much later. Notice the difference in language here. He doesn't say written. It says generated. There's a slight difference here, and you will notice it when the prosecution comes in and does their rebuttal of his argument. Brooklyn, is this a repeat or a new hearing? This is a new hearing. This is a hearing from yesterday.
And I'm concerned, and I'm asking now for the evidentiary hearing to determine why these reports are being generated now, why not at the time the searches were made, and for further detail as to what exactly they did. And that's what I'm asking for, Your Honor. I didn't have these reports when I filed my motion, and I think this is right for the court's investigation to determine what they looked at and why they concealed that from us in the 6 months that we've been here before you. Obviously, this is information that the Attorney General.
Now, usually, I would say this is an excellent argument from the defense. Excellent. Why did they wait? Why did they wait? Now, this is something I would have said also, but I already seen the first 10 minutes of this. That is why I have some issues.
May offer at the time of the preliminary examination, and 6 months go by and we don't know that this had gone on, and I'm concerned about it. So those are my additional remarks. I thank the court for allowing me to make them.
Okay. Go ahead.
Thank you, Judge.
And thank you to Film Freak for gifting a membership. And it went to Heyo! It went to Heyo. Congratulations. You now have access to members-only content on my channel, where you will have most of the videos I publish are accessible to members, or everything from hours to a day before it's viewable by the public. You also have your own emojis here on YouTube, and I have to post a fresh link on my YouTube page, but you will also have access to my Discord if you want to. So thank you, Film Freak, and congratulations to Heyo.
Your Honor, I guess first and foremost, I think what Mr. Gleason is asking for is what even first-year law students would recognize is a fishing expedition, right? He's asking for a hearing on the off chance that something might be discovered, because the truth is he cannot point to any evidence that has been used or referenced or anything like that that would indicate that any of his clients' attorney-client privilege communications have been breached or broken into or anything like that. The simple answer as to why it took so long for these reports to be generated is because for several months, members of my department had been going back and forth with Mr. Gleason and members of Varnum about the approval of our review team policy. And because they wanted to fight us on that, it took this court stepping in to approve that policy and make it, the rule of law in this case. And as soon as this court ordered that that policy would be put in place, I immediately got with Detective Trigger, said whoever was involved in these searches needs to write a report in accordance with our policy. And that's what they did. And as soon as they got those reports to me, I got those over to Mr. Gleason. He's certainly correct. He asked who has been involved in examining these devices. And of course, I immediately told him exactly everybody that I knew had been involved in these searches. It's certainly easy for him to say these things have been concealed. But again, Judge, Mr. Gleason can't have it both ways. He can't say for months, we think your review team is inadequate and it can't be used. And then months later say, well, your review team should have been being used back then. And why wasn't it? And there's concealment. There's been none of that, Judge.
Yeah, the hearing about the review team was the previous stream I had. And that has been going on for a very long time, or if it was the stream before that. Well, the review team here has been, because in Michigan, the review team is a third party. So the district attorney's office, or here the AG's office, transferred the devices or the things within everything to a third party to do all the things with attorney-client privilege information, everything around that. And then the information from that is then sent out to both parties. And that wasn't done until very recently, because there's been months of that going on between the prosecution and the defense attorneys. So when the defense attorney talks about the reports being generated, yes, generated does not mean it was written at that date. So every information that was put in that file has been there all the time. But the report itself, an automated report which brings out all the information, that is then generated. But since there's been litigation surrounding the taint team, so to speak, that information has to be not adjusted, but completed. So even though I understand the defense here, it looks weird. Yeah, but it looks weird to the public because there's been litigation surrounding everything regarding what happened, what should be in the reports and stuff for quite some time. So it's a good argument from the defense, but it's also a good rebuttal from the prosecution. Now, he could have avoided the snark. He's a prosecutor. He's not me. I could have said that because I'm not involved in the case other than reporting on the case.
I would indicate that these devices were seized, and Detective Trigger, as is noted in the attachment, was in contact with Ms. Peterson's attorneys. And Ms. Peterson's attorneys never said, do not search any of these devices because they contain privileged material. What it says is, when you look through these devices, please be aware that there may be privileged material, and take care not to look at that. And everything that I have seen, and even everything Mr. Gleason has seen, though he might not want to admit it, indicates that that is what was done. There were items that were recognized as privileged. Those items were set aside because that's how the Troy PD does things, and that's how we would want things to be done. The Troy PD is not some police department that has never dealt with potentially privileged material on electronic devices. They know what they're doing, and there's nothing that anybody can point to suggest they've done otherwise. So, Judge, we're objecting to the evidentiary hearing. It is a classic fishing expedition. Not only has there been any impropriety, but even Mr. Gleason has to admit there's not even the appearance of impropriety. There's just the hope that some might be discovered, and that's not what evidentiary hearings are for.
Okay. It's your motion, so did you want to have the last word?
I always like the last word, Your Honor.
Actually, I'll give the last word. But
You get the final word, Your Honor. It's a slight difference. I disagree with Mr. Kessel that I somehow put a pause on anything. When a police officer does an investigation, they're supposed to write a report. They didn't, and they didn't for some reason. And it's nothing's in here says Mr. Kessel told us not to do it, not to write a report. They simply didn't write the reports. That's not a function of my complaint about a tainting. That's a function of a breakdown at the Troy Police Department as to why 8 or 9 detectives didn't write reports when they examined these electronic devices.
Now he goes back a bit. He changes the wording here, the defense attorneys, and I understand why. But to my knowledge, everything the report was generated, but the information in the report is dated. So you can always, with those generated reports, go ask, okay, I need to see the raw data to see when was the information written in the report. And here is how I can interpret this as it actually was written at the time of this, but it wasn't generated until later, is that he doesn't bring that up. We need to see when it was actually included in the reports that was later generated.
And that's the appearance of impropriety when you have 6 months later, oh yeah, we did this general review. We're not going to tell you what our search terms are. We're not going to tell you how we did it. And in Detective Mork's case, not state explicitly, I did not review privileged materials. Thank you.
okay. Well, I've had a chance to review, obviously, the motion, which essentially is just seeking the court's approval for an evidentiary hearing at this point. And the people filed a response, and they attached a number of reports that we've discussed on the record today that appear to cover each one of the detectives that was involved in investigating this matter. I read the cases that were also cited. You didn't really refer to them here when you're arguing on the record today, but of course I took the time to read both of them. One of them is published, one of them is unpublished. The published opinion and the unpublished opinion cite back, of course, to U.S. Supreme Court decision that the court has to take into consideration. I also reviewed every word of the transcript that was provided, looking for some information, even though it wasn't very clear or clearly articulated in the defendant's motion about what specific information there is cause to be concerned about that I could consider may or may not have been utilized by the detectives and may or may not have been in the context of privileged communication. And that's the support that I'm looking for to side with the defense in their request for an evidentiary hearing. Everything that I reviewed, every case, every opinion, really indicated that the defendant would have to make a prima facie case that there's some specific information that was utilized in the course of the investigation that then ultimately led to support probable cause to arrest, the charges that were authorized by the state, that was a violation of Ms. Peterson's privilege rights. And there was nothing specific that the defense presented, nothing that I could see in the transcript that was provided And to be very honest, it was only 2 points within that transcript on page 17 and page 19 where there was even reference to a review of the materials or the devices that were seized, specifically the phones and the computers.
Here is what I think happened here. I believe the defense attorneys jumped the gun a bit. They needed more discovery before this motion happened. So they jumped the gun a bit. As the judge said, there really is not specifics in here. What do you claim is wrong here? What is in this material that you believe is specifically in violation of Ms. Peterson's rights? So I do believe they jumped the gun a bit here. And hello, James Randolph saying hello. Is this case more interesting than I thought? I'm surprised anyone is covering it. I was asked to cover it about a week and a half ago, maybe 2 weeks ago. I was doing a stream and I ran out of material to talk about. And I asked the chat, hey, look into this. And I looked into it. I saw there was already hearings up. And I looked into it. And it is at the start, I thought, well, why are they charging everyone for second-degree murder? I mean, the CEO and 3 employees. And then as we looked into the arraignment, the allegations from the state, we have the lack of maintenance. We have the tampering with the maintenance records, according to the state, the grounding cable was not attached. There was a lot to speak to. This was not just an accident. This was an accident waiting to happen because of both negligence and cutting corners, which means the actions towards the chamber was deliberate. And that makes it different. And also now with the new case out of Arizona, another chamber explosion / burnout. So all of a sudden, okay, but I will go through that other case after we are done with this hearing. That case out of Arizona, which on its face looks like an actual accident. But that will also be very interesting because how many of these chambers explode? Is this a manufacturing flaw that it's too easy to tamper with? Or is it something else? So it has more depth than I originally believed. Brooklyn says, I think the child was too young to receive this service. Well, if it's not regulated, it's up to the owner of the facility. So there's no since it's no regulation surrounding this treatment, there's nothing to say. There's no recommendation at what age, which is also a problem. This should be what you call it. The industry in itself should be self-governed or self-governed and right up the not the what ages anything, but it seems like it's not even regulated within the industry. It's the Wild West. We more or less think this helps against this illness from so it's all about what's the morals of the owner.
In those 2 points in the transcript, there's nothing specific. There's some talk about photos, CCTV footage that outlined what was able to be viewed within the office or within the location.
Oh yeah, the allegations towards the CEO is that she tried to wipe her laptop and instruct people to wipe the CCTV footage of this event. That's the allegation, at least.
In which the incident was alleged to have occurred. Messages that were allegedly taking place between Ms. Peterson and her staff. There was also reference on page 19, but I found that information to be more in line with information that was put forth to support a bond request. Nothing in here that outright gave the court any indication that this information that was cited came from these privileged communications between Ms. Peterson and her attorneys.
This is, thank you, Mirage. Says the other business is being sold. She also hired non-certified ABA therapist who was convicted of medical fraud. So even though they had stopped using these chambers, she needs to be out of business. Yeah, and also this is why there needs to be a civil case up and running, so they can put a lien on the business, on property, on everything. Because if they manage to sell off everything and spend the money, then there's nothing to collect.
So that's the issue that I'm really struggling with to get us to that point where I would be able to support and grant the motion seeking an evidentiary hearing. Without that, really what would happen if I approved it is an opportunity for us to bring in each one of the detectives that had some role in the investigation and question them ad nauseum about information just to see what they would testify to. The reports that were provided and attached to the plaintiff's response, you're saying, why now? I felt like you had requested this information. So the expectation that you seem to be placing on the detectives to write a report confirming an action, I don't know that we would have otherwise expected all of those reports to be submitted on February 5th, because at that point it appears there was very clear communication that came from Ms. Peterson's civil lawyers to the police department, putting them on notice that there was or would be potentially privileged communication on the devices that were seized, and then representations which no one refuted that Detective Trigger reached out in response to confirm receipt and to indicate that the appropriate safeguards would be taken. So I don't know that I would share the position that's being taken at this time, that everyone should have jumped on board at that moment to write a report confirming no action that was taken. My understanding of the request that was being made by Ms. Peterson when the motion was filed was specifically to the state. We want to know who potentially investigated, who potentially had access to these devices, and what, if anything, they saw. And as a result, the reports were generated. If there was anything that I could see in here, again, that could potentially make that argument that there's prima facie evidence being presented, that there was some sort of use of privileged communication that would have been a violation of Ms. Peterson's rights, I would gladly grant the request for an evidentiary hearing. But without that, I really do somewhat feel as though I would be buying the tickets for all of us to go on this fishing expedition. If you had anything else that you wanted to present to the court, I fully was prepared for you to come in today. But just relying on the transcript, which I read every word of it, there was nothing in there that was identified in any way, shape, or form as information that could have only come from a review of privileged communication, and nothing else was put forth. The information that was provided by each of the detectives in their written statements, some of them indicated they didn't even have the technological access to review anything. Others indicated that to the extent that they reviewed anything, there was nothing that contained communication from an attorney. There was some games, photos, documents, things that may have had evidentiary value, but nothing that came from communication between Ms. Peterson and her attorneys.
This I believe she's doing good here, Judge McGuinness. She came in there. She could have, by the filings alone, she could have just not denied without a hearing. But she was expecting more because the defense attorney indicated more.
There was a statement provided by Detective Mork. I think the outcome there was some review that was undertaken. There was a process to bookmark information that should not be reviewed. But ultimately, when they were informed that they could not continue until there was a taint team or other protective measure in place, he didn't even issue a report. So clearly nothing that would have been disseminated to be relied upon for purposes of the investigation. So I think based on everything that I have in front of me today, I wouldn't be able to grant the motion because I simply can't find any specific allegation or specific information that has been put forth to the court that would lead me to believe that there's a basis to conduct the evidentiary hearing. And if I've missed something, I'm happy for you to tell me that I've missed something. But just in general, the reports that have come at this point in time, I found them to be in response to the motion. I also found the timeline that the state has articulated to be in line with the reports. Clearly, this is a situation where, although I think Ms. Peterson alleges in her motion that the state may have failed to act and there was some lengthy period of time where they didn't do anything to protect her confidential or privileged communication, I would disagree because the timeline that I've been provided shows that the day of or the day after the search was effectuated, her civil lawyers put everybody on notice about what could potentially be on those devices. Protective measures seem to have been taken by the police even before the state was involved in the case. And since the time that the state's been involved, which I think they cited the earliest date being mid-March, although I would imagine that they were involved in some capacity before that, it sounds like they had been working through creating the formal process of putting together a team and trying to reach an agreement. And we all know because of the last court appearance, there was some discrepancy on how to do that, but ultimately that's been resolved. And from what I understand, the parties have been able to work through those issues. And I anticipate that discovery is going along in the way that it needs to. So I don't see that there is any evidence that the state unduly delayed action. The timeline that's been presented to me doesn't cause me concern that the police were left to their own devices with no oversight or supervision, and that we don't have the appropriate information at this point to believe, at least where we stand, that the evidence that they relied upon, they gathered through other sources. So I don't know that we can even get past that first step of that analysis as to whether or not that evidence should be suppressed, because there was really nothing cited specifically that is causing me concern based on where we sit today.
I'd simply ask for the opportunity, perhaps when we have the preliminary examination, to ask a few questions in that regard. I think that would be the appropriate time, given what I have. So.
I think that is fine, actually. Again, I don't want it to turn into something where it becomes a fishing expedition in that manner, but I anticipate at the exam that these witnesses will be called, and they're going to be asked about the investigation, and they'll be required to answer. They've now put statements together that were submitted and attached to this particular motion and the response that the people filed. And if anything comes to light that causes you some concern, or it appears that they may or should be cross-examined as to the statements that they've made prior to the exam and at the exam, I will certainly allow that.
Thank you very much.
Anything else?
Yeah, she is very accommodating towards the defense here. And I think she recognizes that there might be some issues, but she, as a judge, needs something more solid. And that is up to the defense to ask for the information, do the discovery requests, and then file the motion. So here they were a little bit premature. So to me, she's doing a great job facilitating this case.
Else that we need to address today?
Judge, other than I think Mr. Gleason and I were talking earlier, speaking of the Tate team, I think we're pretty well set on the terms as well, so we won't need any court involvement.
Sure.
There are other cases I have with the Attorney General where they're a little different, but this one, I think Mr. Kessel and I are going to get where we need to go.
Okay, that sounds good from our perspective and for your client's perspective. Obviously, the case has been here longer than I would typically have a case pending before the court for examination, but it seems like everyone is making good use of their time, and that when we are together in September, we'll be ready to go, and I'll be very confident that everybody has done what they need to so we can conduct the exam.
Yes, right. We recognize that you would have been available to hold a preliminary exam from the get-go. The request is ours to be prepared. So I thank the court for the additional time.
Okay, anything else?
May I speak to Mr. Kessel very briefly before you leave the bench?
Of course.
Your Honor, the Oxford Center in Brighton is going to be sold, and currently the bond conditions prohibit Ms. Peterson from going there. I think that she will need to, if the court will allow it, she should be allowed to be there to empty out whatever's there or to package, and then to assist with the transition of the building to the buyer. I don't think that would in any way endanger the people or create any risk of flight, which are the primary concerns for bond. And I think Mr. Kessel does not have an objection in that regard.
Yeah, Judge, for that limited purpose, obviously, business is sold and, things have to be signed and notarized and that kind of thing. So for this limited purpose, the people would not object to modifying bond for her to get her things out and sign whatever she needs to sign.
Pretrial services would supervise it. She would, again, because she has the tether, would ask permission to go to the location, and pretrial services just needs the permission or the directive from the court to allow that if the court would see fit to do that.
Okay, so I assume every time that we have these discussions, not that it's happening all the time, but we've had a couple of discussions about your client's connection to both businesses, including the one that's in Brighton. I'm just going off the assumption that the parties have resolved any potential preservation of evidence. All of these issues are resolved before I would be asked to agree to modify bond conditions to allow her to do things like sell property, close the business. So I'm relying on my assumption, which I want to place on the record, that all of this has been approved. There's no evidentiary issues, no preservation issues, and that if I give her the ability to physically go to a location to be present so she can close up shop and the business can be sold, this is not in any way going to impact any other agreements or requirements that are put in place on her as far as this case.
Yeah, Judge, I promise if we thought there was any more, physical evidence
Sure.
of evidentiary value, we'd have gone back. I don't think the police have been there in quite some time. So like I said, for this limited purpose, the people aren't going to object to bond being modified on this day for this purpose.
Okay, that's all I wanted to make a record of. That was my assumption, but I want to make sure we put it on the record. So did you have a specific date, or you want to just have the
It's going to require
request?
a series of days, I think. And
Okay.
so I'm just asking for that. Obviously, once the building is sold, she would have no reason to return there.
Sure,
But we just, and again, all of the documentary or other materials, I won't say evidence, I don't think it's evidence, but
right.
those will be preserved. We're not throwing anything out. We're just simply getting into storage so the buyer can come in and take over the building.
Sure, I don't have an issue with that as long as she follows the required notice to pretrial services so that they can ensure that she's compliant. I would permit her to deviate from the otherwise do not return to or do not be involved in the day-to-day operations. And I would assume that she's able to do this without the assistance of any of the former employees that would be co-defendants.
I think there's one person there who's a janitorial person, but everybody else, that would be correct.
Okay, I mean, as long as it doesn't impact the others that are proceeding through the court system as
It
well.
would not.
Okay, not a problem.
Thank you, Aaron.
I'll grant that, and she can provide notice to pretrial services, and they can assist in facilitating. If anything else is needed, just let us know along with Mr. Kessel. We can modify it without you having to come back to court.
Thank you very much, Aaron.
All right,
Thanks, Judge.
thank you.
All right. Yeah, that was the hearing. 2 items. The a little bit of fishing expedition from the defense. That was a bit premature. They needed more specifics, which when they ask for more discovery regarding the things they claim, then it is time for filing this kind of motion. And the judge, McInnes, was completely open for it, which I believe is the right way to do this. Now, the prosecution, bit too much snark in there. But other than that, everybody here seems to be doing their job this far. But you never know. If you've been around my channel for long enough, you know that I attract clusterfucks when it comes to trials and cases. Few cases, I mean, maybe 1 in 20 cases I cover are clean cases. The rest, they're always some kind of fustercluck. And Mr. Jingles is here. This is Mr. Jingles. He is the actual owner of this channel. He is the reason why I do this. I can't say he forces me to do this, but yeah. And he likes to be live on stream licking himself. Yeah. All right. Now let's get into that other case. Let's see, where did it go? Here it is. Dun, dun, dun. Dun, dun, dun. Let's do a swoop first. Swoop, 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 swooba. Yes, that is my swoop. It is the Norwegian fire-farting dragon. You cannot sneak up on that from behind. All right, let's go through this one. And see. I will be up here. No, I can't be up there. I'll be down here. Or beside. For treats for Mr. Jingles. Thank you, Film Freak. I will make sure to buy more treats for Mr. Jingles. I bought him these soft sticks last time. I bought a 3-pack. So he is munching down. Now, Mr. Jingles is a large cat. It does not look like that. Oh, Mr. Jingles is having an only cats moment back there. Mr. Jingles, we are live. You can't lick your private parts live on stream. You might get me into trouble here. All right. Oh, all right. But thank you, Film Freak. I will buy more treats. I will buy more treats for Mr. Jingles. Yeah, Mr. Jingles don't care. Yeah, it's his channel. I'm simply here to to keep it moderately safe for work. Oh, all right. Now let's get into this. A physical therapist died after a flash fire broke out inside an oxygen therapy machine, which is also known as a hyperbaric chamber. At his Arizona medical facility on Wednesday, officials said, marking at least the second such fatality in the US this year. Yeah, 2 this year. Thomas Connor, the case we are currently covering, and this guy. But this time it's his own. It's his own. Dr. Walter Foxcroft was found dead inside the hyperbaric chamber by firefighters who responded to his office. Navasu Health and Hyperbarics in Lake Havasu City after a report of a fire just before 11 p.m. on Wednesday. When first responders arrived, crews found smoke billowing out throughout the building and, quote unquote, an intact hyperbaric chamber that appeared to have had a flash fire in the chamber with one patient inside. The man inside, identified as Foxcroft, was pronounced dead at the scene. A hyperbaric chamber is a sealed tube that is pressurized with pure oxygen and helps treat various illnesses or wounds. Well, that helps or claims they help. It is unclear why Foxcroft was inside one of his chambers. Well, he might have tried to treat himself to something. And the circumstances surrounding the incident remain under investigation. And then he attended the University of Arizona as an undergraduate. Oh, he was a career mascot for Big Red for the Arizona Cardinals. Touro University, Nevada. He earned his doctorate in physical therapy. He founded the Havasu Health in 2024, so just a year ago. So he had that for a year, and then he fucked. He made an what do you call it? A sudden ending of himself. Sudden, unexpected ending of himself. And then it's a similar accident occurred in late January. Late January. So that is more or less what we have here. Now, what does this have to do with our case? Well, if these hyperbaric chambers have a tendency to blow themselves up, the effect on our case, now the Michigan case has other things in it, as in negligence, tampering with the chamber and stuff like that. But here, a defense could be for them to say they blow up by themselves also, and that is a valid defense. It might be a manufacturer's fault. So here now, the prosecution in the Michigan case have to prove beyond a reasonable doubt. For instance, let's talk about that grounding cable wasn't attached according to the prosecution. Well, if the investigation into this Arizona case shows that it wasn't there either, all of a sudden they have a case against the manufacturer of these and a defense for the charged people in the Michigan case. Thank you, Daly. Data from 1923 to 1996 documents 77 fatalities in 35 hyperbaric chamber fires globally, with 25 occurring in clinical hyperbaric chambers. Yeah, and that would make a defense of sorts, but also negligence will also be put into this, because with the knowledge of these chambers blowing up from time to time, then but then does it apply to these? Does that go towards second degree, or do they have to go into lesser included? So with this fact, as Daly supplied to us, can we be sure that this is a case where second degree can be applied? Yeah, as Daly said, they seem to be quite safe if properly maintained. Yeah, but this will probably be a major defense for the defendants in this case, that these chambers, even with proper or even with improper, there are things that make them blow up by themselves. failure to properly ground any electrical equipment is borderline criminal, literally. Yeah. But it's also up, if you have a facility like this, like the ones in Michigan, well, then you kind of have to, as soon as you buy it, unless it's under lease, if you buy it, you have a responsibility to have it maintained at all times. And here we have evidence, according to the state, that they didn't. And not only didn't, one of the maintenance guys, let's see, what was his name? Mosteller, the safety manager. It is claimed that he did the maintenance himself and more or less experimented on it to improve it, to do things with it. And that might be against the protocol for this machine. But that in itself, unless they can prove this is by the on order from the CEO, she might be off scot-free. So there's a lot in this case that it can go anywhere. And that also makes this a very interesting case to cover. Especially, we are very, very early in this process. Very early. For instance, we are a year and a half before trial, at least. And they might plead. We don't know. But it's all, so this case is very interesting because we caught it this early in the process. So we get to see everything going up. So nothing is out the window at this point. But we do know that 5-year-old Thomas Connor was put in that chamber with the claims of this chamber helping with his ADD and sleep apnea. And it should have been safe. Even though it might not help, it should have been safe for him. And it wasn't. It wasn't. And that is extremely sad. Also, it is how do I express this? It is so unnecessary. This should not have happened. This should not have happened. It is. Oh. Yeah. Now, the hearing I'm waiting for has not started yet. So let's talk a bit about this new amended, the Young Thug amended. Let's see, where is it? There it is. Oh, that's just a supplement. Where did it go? Where did the original go? I had it. Where is it? Where is it? On it, where is it? Sorry, folks. I will find it in a second. All right, let's see here. Here we have the original. Dun, dun, dun. Oh, first, Swoop. And again, the Norwegian fire-farting dragon. This is Mr. Steele asking for modify young thug sentencing, which in well, it is about the conditions of his probation. Dun dun dun. Motion to modify sentence. Comes now, Jeffrey Williams, by and through undersigned counsel, and hereby files this motion to modify sentence in the above reference case. In support of this motion, Mr. Williams shows as follows. On or about October 31st last year, Mr. Williams was sentenced by this honorable court. Pursuant to OCGA 17-10-1F, a motion to modify sentence is timely filed within 1 year of the date in which the sentence is imposed or within 120 days after the receipt by the sentencing court of the remitter upon affirmance of the conviction on direct appeal, Gray versus State. Mr. Williams respectfully requests this honorable court to modify his sentence. And that was the original one. Now, this is well within a year. Why is that? Well, we all know that Judge Whittaker is on the short list for Georgia Supreme Court. And the moment she is appointed, another judge will be covering Mr. Williams' probations. So, yeah, they need to have this settled before, because by all accounts, Judge Whittaker will be next in Georgia Supreme Court. And good for her. She deserves it. Bad for us, because judges like Judge Whittaker are not common. Judges like Judge Whittaker needs to be also in the lower courts. Because otherwise, we have judges like Judge Glanville. So, yeah. But this is not the only motion. Then they made a supplement where they go more into detail. I don't know if there will be a hearing on this. Hopefully it will, so we can stream it. So, supplement to motion to modify sentence. Comes now, Jeffrey Williams, by and through undersigned counsel, and hereby files this supplement to motion to modify sentence in the above referenced case. Hold on, let me get this up instead. Where were there? In support of this supplement, Mr. Williams shows as follows. On or about, we already know that. On or about November 8th, 2024, this honorable court entered an amended final disposition to wit, 5 years to serve in prison commuted to time served, followed by 15 years on probation, followed by 20 backloaded years in prison upon the successful completion of the full 15 years of probation. Which means if Mr. Williams does his 15 years of probation, then those 20 years, they're gone. Now, if he during these 15 years fucks up, he's facing 20 years in prison. Yeah. So, better be careful. The backloaded portion of the sentence will be commuted to time served. Pursuant to OCGA, that one, Mr. Williams timely files this motion to modify sentence, supplement to motion to modify sentence. This honorable court is also authorized to modify any part of the probationary sentence at any time during the probationary period pursuant to OCGA 42-8-34. And timely filed, and here is the gist of it. For now, Mr. William respectfully asks this honorable court to consider modifying his sentence to, quote, upon successful completion of the full 15 years of probation or less, the backloaded portion of the sentence will be commuted to time served, and Mr. Williams shall remain in reporting status for the first half, 7.5 years of his probation, unless shortened by this honorable court. What does this mean? Well, this means that in the original probation sentence, there was bang, 15 years probation with no possibility of having the probation shortened. This is what they are asking for. We want at least the opportunity to have the probation shortened. And it seems like they are asking for down to 7.5 years, and then ask for it to be completed. That is what I read into this. Yeah, 15 years probation is a fuckload of time, because in this, he can't be around felons. And I hate to admit it, but the rapping industry is kind of full, has a bunch of fellows in it. So he has to be cautious about who he hangs with, who he goes on tour with. If he's playing festivals, who else is going to be there? I mean, he has to be cautious for 15 years. And they want the opportunity to have that shortened. At least file for an amended, shortened the probation period. All right, so that is all I have until the hearing and until the decision from Judge Whitaker. That I wish I had more. Well, I wish I had more on that. All right, let's see now if the hearing has started. There should be a hearing today. Let's see here. Not there. Not there. Darn it. Let's check that one. Dun, dun, dun. Dun, dun, dun. Let's see if I can find. No, it hasn't started yet. It should be starting soon. All right. While we wait for that, how about some Judge Simpson? Let's see if he... If I am correct, this might also be... this today is his landlord docket, which means we might hear more about the Arbor 1 slumlord case. So let's tune into what he has been doing today. Well, hold on. Oh, he's there. Why does she look like Greta Thunberg? That's unfortunate. I'm so sorry, love. You seem like a sweet lady. With a fortunate, you bear some resemblance to Greta Thunberg. I'm so sorry.
Court does call the case of Dale Gretsch versus Taylor Adams.
Hold on. Yeah, Judge Bev left criminal court and is now seated in the civil court where the O'Keefe family has its civil suit against Karen. Yeah, as far as I know, this is because she jumped, because they are being switched around a bit all the time, the judges over there, and she was already scheduled to be switched, and somehow she ended up in that court where the O'Keefe family has its civil suit against Karen. Now, the civil suit already have a judge, and I checked with the local attorneys. It should not. She should not be anywhere near that case. Should not. But with Judge Bev, you never know, actually. You will never know. It's unnerving. Why out of all the courts, why was she switched to that one? All right, let's continue with Judge Simpson here.
Good morning, Your Honor. Alex Barry Santoro appearing on behalf of Plaintiff Dale Gratch and Dina Davis, P81545. Nice to see you.
Good seeing you, sir.
I
And
have,
this is.
I have closed captions on, but it's not
defendant's
showing.
Objections to garnishment?
That's accurate, Your Honor. I did file a writ of garnishment, and there was an objection served after the 14 deadline to effectively stay the garnishment. So I'm here today to see.
Object to any stay of the garnishment. Right?
Yeah, that's the lawyer.
I'm brilliant. I figured that all out on my own.
Yeah.
And they're not here. Taylor Adams, Tiffany Gross.
Do you want me to call the hall or something?
Well, Adams, Gross.
No, I know them.
No.
The landlord docket here sometimes gets spicy because I saw a case from last week where the landlord and the tenant, they didn't get along at all. The landlord switched off the Wi-Fi, and when the tenant was away at work, he went down there when she was away to some medical. She has some medical issues, so she has to be away to get treatment. He goes down and unscrews the light bulbs to save energy, and she has this nerve illness of some sort. She shouldn't be on ladders, but every time she comes home from one of these treatments, she had to go on a ladder to screw in the light bulb again. Judge Simpson wasn't happy about that. So sometimes these landlord-tenant hearings gets spicy.
The defendant having failed to appear, the motion regarding the objections to the garnishment are denied. Garnishment may proceed. That denial is based not only on the defendant's failure to appear, but also on the merits of their objections.
Thank you, Your Honor. I appreciate your time.
Thank you, sir. Jim Shen versus Fatima Stevens.
Fatima Stevenson appearing on behalf of herself. Good morning.
Good morning, Your Honor. Jay McCurgy on behalf of Jing Mei Shin, P8321.
All right. And this is your motion for relief from judgment, ma'am?
That is correct.
All right. What do you want to tell me about it?
Council and I originally in late May, I believe, were discussing the option of me purchasing the home that I'm currently renting because at that time I was made aware that the owner was intending to sell the home. So it would have benefited all parties if we were able to make this transaction occur. It has taken a little bit of time. We've all kind of, well, I can't say we've all, but council and I have corresponded through email, as you've seen. The property manager, who is also a realtor, and I and the realtor I had secured recently have also been in communications as of yesterday. I was just made aware late yesterday afternoon that the property manager who was in correspondence with my realtor and lender is not the listing agent. So therefore had no authorization this entire time to work on the deal. And so, anyway, long story short, I had not looked for alternate living. I wasn't intending to seek alternate arrangements to move out because my intention was to actually purchase the property. It wasn't going to be a quick thing, but it was going to take a little time. But as long as I showed progress and all the relevant parties that were interested were kind of kept in the loop to showcase good faith that we could move forward with that and stay the eviction.
Response.
Thank you, Your Honor. The home is not currently for sale. Hasn't been listed yet. My client wants to get the property back.
But, okay, just so that I'm clear, the original this conditional order of dismissal was put into place with contemplation of a sale?
That's correct.
No, Your Honor.
Oh,
That is not.
oh. Disagreement.
Stevenson is representing that we've been in discussion for sale of that home. That is not accurate.
Okay, but was there somebody well, let me ask this. Whether they had authorization or not, was there somebody operating on plaintiff's behalf that was leading toward a sale?
So there was a, after the affidavit was sent in late June, Ms. Stevenson sent me this email that she has, I guess, attached to this motion here, that she's been approved for a mortgage.
Okay.
And as you can follow through this email chain here, essentially, she wanted to put together an offer, and I said, if you're going to do that, you might want to do it quick because we're running out of time here. And that's essentially where that conversation ended on my part.
Right, but there were also other individuals that
The
were.
text messages, Your Honor?
Yeah, well, there are other individuals that are involved that are seeming to indicate that the purchase.
On the plaintiff side, Your Honor, there is a realtor who's the property manager who asked Ms. Stevenson for a pre-approval letter or something at some point. Nothing was provided. I have an email chain here that I can submit for the record. Let's call it and it clarifies what happened.
Clarifies. Well, okay, so here's what I'm getting at. There's someone on the plaintiff's side that is talking to somebody on the defendant's side regarding the sale. I'm a bit concerned because as I'm hearing you, the person on the plaintiff's side is a realtor, right?
That's correct.
There are, it seems to me, discussions that are going on regarding, between the person that's a realtor on the plaintiff's side and a realtor on the defendant's side.
So the person who's a realtor on the plaintiff side has no agreement to sell the home. There's no,
I get the fact that there may not be some agreement between
No way.
plaintiff and this person.
okay, in no way does this person represent the plaintiff or their interests.
In some way they do, don't they?
So, Your Honor, I think the statement that this person is the property manager is incorrect because this person has told me they're not the property manager of the property.
Who are they then?
They helped,
Vis-a-vis the property.
they helped the homeowner purchase this home or find this home as a property for their portfolio.
Say that again?
They helped the homeowner find the home as a property for their portfolio. As an investment property, this property.
Okay. Okay. If that's all they are, why are they entering into discussion?
Your Honor, I don't know. If we look through, I have an email from that person, in an email chain that both Ms. Stevenson and I were included on from yesterday, and it describes an email between her realtor and this other person describing what.
This other person being whom?
The person's name is Kirk Glassel.
And that's the person that,
Mr. Defense Attorneys, why is this news in this case that seems to have been up before Judge Glanville? No, up before Judge Simpson. Before? Why is this news to Judge Simpson? Why is this news?
that now you're saying is nothing regarding this property?
That's correct, Your Honor.
Then why are they involved in an email chain?
This email, so Ms. Stevenson, I would say, was speaking to a realtor. This realtor reached out to this person they believed to be the real estate agent for this property, although that wasn't the case. And they had a discussion of this email that both Ms. Stevenson and I were.
Turn off that
Who's
phone.
up? And no, go ahead.
Yeah, this email that we were both a party to verifies what that discussion was and that they, what they believe the intent of that discussion was.
If I could clarify one thing, Your Honor. In the email from counsel, it clearly states in the email that I had submitted with a motion for the recommendation was for me to send the offer letter to this individual in particular, and then.
This person who now is being claimed to be nothing.
Yep, exactly. That's.
I do have other.
Well, okay, but hold on, folks. This may make sense to you, it doesn't make sense to me. Why would she be sending an offer letter to somebody who really has no affiliation to the property?
Oh, I was thinking he would communicate that offer to the home. Should there have been an offer? Because I'm not.
Then, right, but is, okay, Mr. McCurdy, that's part of my problem. Part of my problem is this person and your client may be saying they have nothing to do with the property. Apparently, the defendant believes they do and is operating with some apparent authority. And you yourself also may not know what that position is, but like you said, I'm not a realtor, but this person is doing something. And the very fact that the person is a realtor, I think that there certainly is the potential for some confusion regarding that. And I think that's part of my
I do have more recent communication as of yesterday with the same person.
with who?
With that same realtor and my realtor and the lender.
And the lender?
So if Your Honor, if
Go
I
ahead.
clarify, I have an email right here between all parties just clarifying what has happened in an email. And the email includes her realtor, the email chain includes an email from
Okay.
her realtor, back and forth. I believe it's relevant.
Okay, but Mr. Mukherjee, the very fact that all of this needs to be clarified, isn't that a problem?
So, Your Honor, after I spoke to Ms. Stevenson yesterday, she made it clear that she was gonna believe that she's been misled here. So I reached out to the realtor to see what was going on. If she hasn't misled, if there was discussions with the loan officer, if there was discussions with a fellow realtor. And what he described to me was something close to what we're talking about here, but not, but missing the target by a little bit. He believes this was a last minute attempt to confuse the situation and stay the eviction. And he clarified that in an email because the realtor who reached out to him had not signed an agreement with Ms. Stevenson. It was just an informal discussion about what, if that property were to be for sale. Now, he clarifies in the email that I have in front of me that he doesn't know where these numbers are coming from and that he.
What numbers? The offer?
Yeah, correct, Your Honor. Because no discussion had ever occurred about what that listing price would be. No discussion occurred about a wire transfer.
Okay, all right, but counsel, something's going on. I have two realtors on opposite sides, regardless of what their authority is. All right, I have two realtors, and then at some point, according to the defendant in this case, there are communications with a lender. That.
Uh-oh. Yeah.
The
Go ahead.
realtor the realtor who's standing on the plaintiff's side had I don't believe had any communications with the lender for Ms. Stevens.
Is that right or no?
I have email here with Kirk Glassel in communication, several phone call or a few phone calls, I should say several, with my realtor, and she was relaying information between him to the lender. And there's including the good faith deposit, the amount of that, including something about a back rent that and all of these other components that would.
Okay. Okay, that's my concern. It may very well be, Mr. Mukherjee, that your client gave no authority for this person to act in this fashion. But what's clear based upon the representations of the court is that they were. And I don't know.
It looks like it. Looks like it. Yeah, it seems like girlfriend/tenant trying to pull something off here. Oh, well, when I told you when we started looking at this, Judge Simpson's landlord-tenant court, sometimes shit goes down. Sometimes shit goes way down.
Ms. Stevens has been putting forth since the conditional dismissal that she was wanting to purchase this home.
Mm-hmm.
After the affidavit went in with the order, I received this email saying, I've been approved for a mortgage. I'm going to try and put together an offer for this home. If any of those things are true, I don't know. Beyond that, no communications until the writ was posted to the door. And then all of a sudden this started as of last Thursday or Friday. If Ms. Stevenson would like additional time, we're happy to accommodate her. We can make any arrangements she finds like reasonable. But I don't believe the writ should be overturned.
Oh, yet Simpson is not happy. Oh. Oh, he's not happy.
Yeah. Evidentiary hearing. I don't know what I can do. When did we set the current?
August 11th.
Okay. Afternoon.
This seems to be an accurate interpretation of what's going on here. She pretended to want to buy the home, get a realtor, no communications to owner, but tell the judge you want to buy. That's why you haven't left. Slow roll, scam, so she can stay for free. Yeah, that seems like what's been going on here.
Yeah. So
Okay.
yeah, it was already at 1 p.m.
Got it. I understand. The problem that I see here is that there's something else that's going on, which, as the defendant has stated, led her to do or not do things. Plaintiff may have a different version that she's coming up at the last minute, doing whatever. Regardless of all of that, I have two realtors. I all of a sudden have a lender involved. I would just say that if Miss Stevenson has gone to those extremes just to delay, it's a lot. I don't think that that's what she did. I don't think the communications that I've seen and the ones that are being described are that. Something, rightly or wrongly, it seems to me, was represented to her regarding the sale of this property. Okay.
Property was never listed. That's
Right, but I don't,
okay.
I hear you, but if you had your, from the plaintiff side, your everyday run-of-the-mill property manager, not a realtor, they're just managing your property, make sure that repairs are done, collect whatever, okay? And she's having discussions with that person, then I might tend to agree that there's not enough there doing anything. This is different because this person's a realtor. And by the way, I don't think somebody goes up when somebody's a realtor and say, do you have the listing? I mean, I don't know that comes out of anybody's mouth right out of the gate, unless it's the realtor that says that to somebody. You assume that they have the ability to sort of move in the way that they're moving, right? So I get it, but something transpired here that either Miss Stevenson was misled potentially, or something occurred where she just didn't understand it and how the transaction was going to go.
Or it's the other way around.
Or something. I think for your client, Mr. McCurdy, I don't know if she knows what the heck has transpired. Because somebody is apparently, well, I'm not making this conclusion, but at least from Ms. Stevenson's perspective, somebody is acting on her behalf or their behalf. And it's just, it seems to me doing things and making things that may be representations that have to stick to your client. But I don't know. Now, having said that, other problem, Ms. Stevenson, that you have is typically any agreement regarding the sale of property would need to be in writing.
That's
Right. But so there may not have been an agreement, and that may be this court's ultimate conclusion. But I also realize that there are discussions that happen before there's any writing that's put into place. I mean, just in a practical sense. So from what I've seen today, I think it would be improper and imprudent on this court's part to to allow the writ to be executed. So at this juncture, the court is going to stay the order of eviction of the writ in this case. I'm going to order an evidentiary hearing on the issue regarding a sale. I will set that for August 11th, and I apologize for pushing it out to that point, but my docket is what my docket is, folks. And I'm going to try to take a vacation, or at least not be here. So August 11th, 2025, I will set that at 2 p.m. Okay, there's a criminal evidentiary hearing ahead of you, and I've got to take care of the criminal matter. But in the interim, I might suggest that the parties try to talk to get straight exactly what's transpiring on the plaintiff's side and what may have been said. Ms. Stevenson, you also, and one of the things that you said this morning is that you hadn't had time to make alternative arrangements regarding yourself. So I might suggest that you at least have a plan B, because I don't know what I'm going to rule on this. All right?
I agree.
All right. Thank you, folks.
Thank you, Your Honor.
Thank you.
Why? No, I'm going to give it to.
I actually think here that Judge Simpson. Now, we don't have access to the communications as Judge Simpson has in their filings, but yeah, I think he got it on the face of it. I think he got it switched around, but who knows? Who knows? Hi, Dave. No, we covered the Hyperbaric Chamber case the first hour. You're late. You're late, Dave. So now, as we are awaiting the next hearing I'm expecting, we are checking in on Judge Simpson.
Why are you appearing here?
You don't put that on the front, yes.
This is that one.
Yeah. However, she filed more stuff. Defendant.
Okay.
Yeah.
Thank you. Court does call the case of BMC Rio LLC versus Nettie Whitlow and Yolanda Whitlow Tice.
So I'm
Morning, Your Honor.
Good morning, sir.
as I said, I'm expecting another hearing. I think it's the latest I saw. It should begin at 11, which is in 10 minutes. Once it's up and running, we will go over there. But for now, let's check in on the landlord-tenant docket. And I said it in the beginning. These things get spicy sometimes.
Morning, John.
Good morning. State your appearance, please.
Right. Ian Redmond, P70599 on behalf of the plaintiff.
And your name, ma'am?
Doshia Banks occupant.
Pardon?
Doshia Banks occupant.
Doshia Banks occupant, Your Honor.
Okay. So you're not Miss Whitlow?
No.
All right. Why
So-
are you there?
What is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the.
What? Claim to be a tenant, then file bankruptcy to stay. Now the bankruptcy is lifted, and here they are again, apparently.
Case. The order lifting stay I would like to present to the court because it has some interesting language in it, Your Honor, which includes it is
I'll be up
further
here.
ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud VMC REO LLC.
Oh,
Additionally, Your Honor, the bankruptcy
Two in a
court
row.
ordered. Let me see. Notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinecrest Estates Drive, Ann Arbor, Michigan, the property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you.
wow.
All right.
So, my interpretation, she's a squatter who then, in order to avoid being thrown out, made a lot of claims. Those were, of course, rejected, and then she filed for bankruptcy. And in bankruptcy, everything against the person gets stayed until the bankruptcy case is ruled upon. And it seems like the court said, go fuck yourself. We're lifting this back to court. That is my interpretation of this. 2 in a row. 2 clusterfucks in a row. I said it. Judge Simpson's landlord-tenant docket gets spicy sometimes.
Thank you.
I will note, Your Honor, that Ms. Banks has filed an appeal of that order
Of course she has.
in the federal Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay, and that order lifting stay holds until such time as the appellate court does something. Additionally, Your Honor,
Yes, go ahead.
Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor,
There's more. Go ahead.
there's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlow, who, as far as I know, actually exists, but I don't have any evidence to that effect, has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case, and in a federal case, the federal court issued a show cause order to Ms. Whitlow that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know that
Seems like we have a professional scammer there.
need that because
Okay.
I'm not.
The reason that I mention all of this, Your Honor,
Go ahead.
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself. The order lifting the automatic stay talks about that scheme of fraud. I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
Oh, that's an interesting way to force her.
Yes, Your Honor?
What do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But I, Doshia Banks, is respectfully appear, specially and conditionally, for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well,
she's a sovereign citizen. Oh no. Oh, please tell me she's a sovereign citizen. Oh, wow. What did we get ourselves into? What did we get ourselves into? Oh, this is amazing. Poor Judge Simpson. You can see on him. Oh no, I didn't want this today. Oh, this is amazing.
then you are not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and
No,
then
I have
you
a
can
lease
go
with-
challenge it. With who?
Whitlow. Ms.
Then
Whitlow,
you need to go against Miss Whitlow.
Oh, I assume her and Miss Whitlow are the same person. And she's trying to scheme this by using an alias and then having a lease with that party. And now she's trying to insert herself as a named party. No, as George Simpson said, if you're not a named party in this case, fuck off. Well, he's using his own words, but yeah.
Pardon
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to,
I don't know what you need to do, but
well, let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part that that I stated that I'm not, oh, I lost my spot, not consenting to this court's jurisdiction. So I'm going to recant that
So you are consenting to this court's jurisdiction?
at this moment.
Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
Okay.
You know what? Here's the problem. You've not filed anything with this court.
No.
So I don't know why, on those grounds, why I'm hearing from you.
Okay.
So this might be a default judgment. Oh, ha! Just because she thought I'm going to walk in as a separate person. Yeah, no, not working, not working. Yeah. This is not the first rodeo for Judge Simpson.
If I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under
An
false
answer and
pretenses
counterclaim to what?
to their complaint for eviction.
You're not a named party. You're not a named party in this.
You have a lease with, allegedly, with Miss Whitlow.
Correct.
Then that is who you need to pursue it against,
Okay. And
or whatever the heck you're doing.
well, and
Because you don't have, there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
Oh, this is going to be a separate video.
okay, I'm not really understanding, but
No, because you're a dumbass.
Well, let me put it a little bit more simply. If I grant the relief of the plaintiff in this case and grant an order of a judgment and an order of eviction in
Okay.
10 days,
okay,
any claim of your interest in that property, you have to go after the Whitlows, because that's the only person you have a contract. Allegedly have a contract with.
okay. No, there is an actual contract.
I don't know that, ma'am.
We've actually been.
I don't know that.
Okay, I know you don't know that 'cause it's not before you.
Correct.
I see, I see. So basically, the notice of removal that the Whitlows did,
They are not here. I don't know. I have documents that are not, that they filed with this court that are not signed. So I don't have to accept them. She has not appeared before this court, or they have not appeared before this court. And so as far as I'm concerned, any relief they're requesting, I can, and as of right, ought deny, and it should be denied also on the merits of whatever their motion is. But I can deny it because they're not here.
okay. again. Say it to
Again?
me. I want to make sure I'm clear that my issue is with the Whitlows, not with VMC.
Ma'am, I am not giving you legal advice.
No, I
You're
don't-
telling me that you have a contract. I do not know that you have a contract, but if you wish to enforce that contract, that's who you're going to have the issue with. You're not going to have the issue with the plaintiff in this case because they have rights on the property.
Okay.
Oh, she's not giving up. Oh, lady, go away, move out, fuck off. Oh, this is funny. I told you guys, your Simpsons court, landlord-tenant court,
All right, Your Honor, I will
shit happens.
speak with the Whitlows that I have finally got an understanding of everything. And I will speak with plaintiff's attorney as well and continue to communicate with Remax, who has came by the house several times.
All right.
Oh, I think
Based
I'm
upon
going
the
to stay with
representation of
Judge Simpson
counsel,
for a
I'm gonna
while.
grant their motion to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of my signing. Should the matter be appealed, also contained in that judgment and order, the appeal bond I would set at this time at a rental rate or a rate, and I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month that would need to be paid to maintain the appeal.
Thank you, Your Honor.
All right.
I will prepare that. Oh, Judge Simpson, let's make sure. $15,000 a month. Oh, yeah. Yes.
Presented to you this morning.
Thank you.
May I say something? Our lease payments was not that high at all.
Not his problem.
I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order.
That is, you need to get the Whittlers in here, which will be very, very hard because you're probably Whittler. So she has to come in as her alias. Look at the smile on Judge Simpson. He knows exactly what he's doing.
Thank you.
Thank you, Your Honor.
Thank you.
Oh, that was amazing.
I know, you didn't write it.
We'll await. I did.
Oh,
No.
no, I don't think so. I don't know if Mr. Fink is ready on.
Mr. Fink, are you ready? But hold on. I'm going to take about a 10-minute break because my head is hurting right this minute. Well, it's not hurting. I mean, I could go on, but I need about 10 minutes after that.
Thank you, Your
Honor. Court's in recess.
Oh, wow. Oh, that was amazing. Oh, this is so going to be a separate video. Oh, oh. Yeah, so she allegedly, as an alias, rents this $1 million property and shenanigans ensues. He probably doesn't pay rent at all. And they have been trying to get rid of her for quite some time. And in this scheme of hers, allegedly, She then filed for bankruptcy, which means everything goes to stay. They can't continue with the eviction. Then the bankruptcy court said, fuck off. And now it's unstayed. And then she tries to go to court as herself, renting from herself under another name to get this. And she had no standing whatsoever. So this was more or less a default judgment, which Whitler, or whatever the name was, now they can come in and appeal, which will be a problem for this lady, because then she has to come in as her alias. Now, I would not be surprised if we, in a later landlord-tenant hearing, will see her come in as her alias and try to... Oh, that was amazing. Yeah, I'm going to stay with Judge Simpson. And he had a longer than a 10-minute. Oh, that was amazing. Whitlow. Yeah, Whitlow, the alias. And break is over. Oh, I wonder what happens next. This is a good start. This is a great start. Oh, wow. Oh, wow. I mean, both those cases deserve a separate video. And I will post those. Because I'm going up to my nephew, my godson's wedding. Driving up there on Wednesday, and I will stay until Sunday. So no streams Wednesday through Sunday. But I will have these videos prepared, so you will get something from me Wednesday through Sunday. Yeah, it took an extra long break. I mean, oh, that was so funny. That was so funny. Okay, he forgot to turn the sound on. No, you're Simpson, you forgot to put the sound on. There you go. Oh no, did we miss? No, why did you why didn't you turn the sound on? You're Simpson. What did we miss out on? What did we miss out on? No. What did we miss out on? No. Oh God, no. Oh God, that must have been epic. No.
You just
Okay.
To throw things in people's face.
you just done it for the last 5 minutes.
No,
Yes, you have.
I'm just.
You just do it nicely.
I'm doing amazing for parody.
Oh, I wish we could have heard that one. So it took a 10-minute break.
Case is dismissed. Plaintiff's claim is dismissed without prejudice. Defendant's claims are dismissed with prejudice. You may file your order.
May I approach?
Yes.
Oh no. Oh, I don't know what happened, but that would have, so Judge Simpson came back from a 15-minute break, and another clusterfuck appeared. Oh, I wish he had sound on.
Okay. Dare I ask, what is the next one that we want to do? Because I'm not calling it, because I thought I called the easy one first, but that
My suggestion for the remainder is that we do them
got it.
separate rooms all at once. And I know you have Ms. Armani's case yet, but all the rest of them, we might get through some of them. I'd like to resolve all of them. And we received some information from Mr. Campbell last night that may be helpful in resolving them, but I don't think we'll be able to do it on the record and have free discussions and negotiations.
That's fine, Your Honor.
So I'll probably need both parties back to at least know what the issues you have.
You want to be in separate rooms?
I think we should be separate. It'll be easier for both of us if we can
Okay.
speak freely.
That's fine.
Much as I would enjoy spending time with my friend Ms. McFarland, I think it'll be better to resolve her case and the rest of them if we're separate.
All right. So why don't we do this? Why don't we
No,
put Mr. Fink and
I want to
people
hear
in
them.
the jury deliberation room. Make sure there's not a jet there.
no, please
Then-
no. I wanted to hear those in open court.
Thank you.
Thank you.
Yeah,
Okay.
it seems like this attorney has
Yeah,
several
sure.
cases with the same type of
And you
shenanigans.
got your clients here.
Yes. Yeah.
Okay, so why don't you guys stay here?
Okay.
I'll do that, and then where is, yeah,
Are you gonna, Dan, Your Honor?
Pardon?
I have an interest in the Anderson v. Lyman case. So are you gonna hear that while we're in back? I can watch it later if you are.
no, I'm gonna try to get through some of this and then get to that one. And Ms. Lyman is here. Where? Pardon?
One of them.
Oh, okay. All right, where are they going? They're just busting out in this. So here's the deal. You gotta watch her. Okay, yeah, you gotta watch her. Causes a lot of problems. They can go ahead. You can take them back. I just point out trouble when I see it.
Take a photo of the order you just signed on the Kaiser case.
Say what?
Can she take a photo of the order you signed on the Kaiser case?
No, I didn't get a copy of it. I just wanted a copy from the record. What? I know, I'm just being really difficult this
You
morning.
are.
Or is it already?
When, yeah, I have no idea.
Oh,
No. We'll find a way to get her a copy.
okay.
She'll be here for a minute.
Thank you.
Okay, now as to Ms. Bauer,
Yes, sir.
as to the cases involving Mr. Fink, he's now left, but legal services is involved with all of those.
Yes, it would be O'Day, McFarland, Terman, and Jordan.
Okay. Because I had 4. She took my files down there. Okay, then what I'm gonna do is I'm gonna stand in recess. I'm gonna talk to the plaintiff first. Then I'll come back. I will get to you guys.
Okay.
All right?
All right.
Aw, I wanted to hear the rest of those cases. Let's see here. When does he come back? And we are up to live, and he hasn't come back yet. Oh, darn it. What can we watch while we wait for him to come back? What can we watch? Let's see here. What's going on? Dun, dun, dun. See what's on there. Nope. What's on there? Nope. Well, George Boyd is on. George Boyd is on. So we can watch that for a bit. while we wait for him to come back.
Who's your attorney? Butler who? Sure. Just have a seat. We'll get back to you. Anyone else? All right, everyone. These are the rules of the court. Number one, you're going to need some extra patience in your pocket because Odyssey is not working appropriately, which I think we all knew that this would happen. I was told that there was a backup plan. I have never seen the backup plan. I'm not the person who installed Odyssey, so I have absolutely no control over that. I'm not a computer expert, so you're going to have some patience in your pocket. The other thing I was told by an attorney, thank you, Mr. Maurer, is people who are being sentenced, just so you can let your family know, once a judge has sentenced your relative, if somebody calls and says, if you give me $4,500, I can get them out of jail because there's this new law. There is no new law. So it would probably be best for your relatives, if somebody is calling you, asking you for $4,500, to call the previous attorney and ask them what this is about, and they will be able to tell you that it's a scam. Do not give money without asking questions. Do not give money without doing your due diligence. Otherwise, what's going to end up happening is you're going to be out of $4,500. Your grandmother is, or somebody else is going to be out of money. So don't let that happen to them. And it'll probably take an act of Congress to find the person who took the money. So let's not do that. We are going to be recessing at 12. I say that every day, but today it's going to happen. So everyone, the files are there.
She never recesses at 12.
Grab your file, confer. You're not ready to approach the court unless you confer with the state and confer with your client. If your client is in custody, ask the deputy to have them brought out, and we will take you up, and we will take you up as quickly as possible. Hopefully at some point today, Odyssey will return to us. But if not, we're going to go old school, which people don't know how to go old school, but we will.
Paper, paper, paper.
And we're ready.
No, they should have a file.
Yeah, it is her mother that
here's the
buys
thing.
Judge Boyd new
And this
purses.
is not for you. This is for
No, I've
Commissioner's
seen that
Court and
one
everybody
before.
else who decided to do this Odyssey system. Nobody has a backup plan if Odyssey isn't working. And I kept saying, if you load up every file in Odyssey and it breaks down and you don't have a hard copy, then what do? This is what we do. You know, nobody's MacGyvering.
It's the Bear County way.
It's the Bear County way. So who is your client?
Jonathan Dreamer. It's a
Jonathan Dreamer?
Yes.
If you'll come forward.
Yeah, Judge Boyd has a new, well, she alternates between, 20 or so purses. Her mother
Hello,
buys
Mr.
her
Dreamer.
new purses for birthday, Christmas, and once in a while.
Good morning.
And there's
All
always
right.
a fresh
You're
bouquet of
scheduled for
flowers.
jury trial, correct, counsel? And state, are you ready for trial?
We're ready, but CTD is up to still in trial.
Well, we can do 2 trials at once, but we're not. All right, Mr. Maurer, this is what I'm going to want to happen. I'm going to have him recalled for tomorrow.
Okay.
So we can see where we are on this trial, and hopefully by then we'll have the Odyssey system up and running.
Okay. I'm starting in Wilson, but it shouldn't take very long, and I'll just. But you know, we wouldn't start till the afternoon like last time anyway, right?
Yes.
Okay.
All right. Norma,
Yes, ma'am.
I need a reset for tomorrow for Mr. Dreamer, and it's for trial. All right, thank you.
I'm a bit surprised that Law and Crime has nothing at the moment. Usually there's something going on, a hearing or anything. Yeah, it's not a holiday, is it? It's just summer. I can skip ahead until the next one is up.
Carbon copy ones.
Oh, yeah, bring out the carbon copy. But
I
yeah, you
have
all are gonna have to
captions
go old
on, but
school.
somehow it's not working at the moment.
It's like, you know what's so funny?
Like here, piece of paper in my pocket.
Oh, yes. And you know what's so funny? Nobody knows how to go old school.
No.
And old school is like you pull up your police reports and go there.
Not with this, Mark, why do you print all these reports? I said, because internet goes down and then you don't have any reports.
Sadly, my channel isn't big enough to have closed captions yet on live streams.
Okay.
Skipping ahead a bit. Oh,
Hi, Mr. Cavazos.
Good morning, Judge.
Good morning. So Odyssey is down. Who do you have?
I have Eric Rodriguez. He's got 2 cases on the docket.
Eric Rodriguez, if you'll come forward, please. Okay.
Yeah, we're trying to locate them, so.
Because I had them yesterday. I had the files.
everybody in Judge Boyd's court is scrambling for a copy for a printer.
Hello.
Morning.
Morning. A day without Odyssey. Is it a joy? I don't know. We shall see.
I thought it was just me this morning. I didn't realize it was everybody.
Oh, no, everybody. And you know, I don't believe there's a backup plan.
Why would we plan for that, right? That goes against everything we stand for.
And you know, whenever I bring up backup plans, because I'm always thinking you should think of worst case scenarios, right? My questions were never answered. Like, what's the backup plan? You're making more room because all the files will be gone. But if Odyssey fails, what's the backup plan? And guess what? There's no backup plan.
There is none.
No. So, Mr. Cavazos, just be
Yes, ma'am.
patient with us. We're trying to see if there's a physical file.
Yes, ma'am.
There may be a physical file, there may not be. But what are we here for today?
Judge, there were a couple things. One, Mr. Cavazos has filed an amendment to Mr. Rodriguez's bond. It was something, essentially it involves, previously, Mr. Rodriguez was unable to see his child without supervision.
Okay, I remember you all discussing this with me.
Yes, ma'am. And the state did look into it. I did talk to the mother of the child. We have no concerns about amending that condition. I think you would ask Mr. Cavazos to get the CPS order as well as maybe some other
Yes.
paperwork, which I believe he has supplied to. So the order then was given to the court, but I believe you may have been in trial at the time.
Yeah.
So I think we had reset it till today for you to make a decision on
And does
that.
he have a pretrial services officer or no?
I believe he does, but do you know, does he have?
Eric, who's the individual that you report to?
I can get you the name on the phone.
Okay.
I can need it today.
Yes, who is the person?
I'm gonna get the name, man.
All right.
She's loading.
Technology. It's all around. So.
Oh, it is.
How often do you report, Eric? Can you answer that?
Once a month. I have to report today.
There's two. All right, thank you.
I mean, yeah, I know.
Officer Mendez, Officer Mendez,
I'm sorry, who?
Officer Mendez.
Let me see. What's the first name?
It doesn't show, it just says Officer Mendez, pretrial services.
Would it be Celeste Mendez?
Or no.
Let me try. Maybe it's, but it also could be Roman.
Do you have a phone number or an email for them, Eric?
It's a 188 number. I think it's gonna work. Call it.
No, it shouldn't be an 8 number.
I get a text every, I will text a reminder every month.
All right, well, do me a favor, text them and tell them that the judge wants to speak to them. All right, we're going to go on the record. Court is calling 2021 CR 0735 State versus Eric Rodriguez. Can I have parties announced for the record?
Stephen Spear for the state.
Jaime Cavazos for Mr. Rodriguez. There is another case also, Judge, on your docket for Mr. Rodriguez.
Yes, I'm sorry. And also 2021 CR 0699.
Correct.
And are you Mr. Eric Rodriguez?
Yes, ma'am.
All right. So we're here for, the first thing we're here for, it's in regards to having contact with your son. Is that correct?
Yes, Your Honor.
All right. And your counsel in the state did discuss with the court what the issues were. The court wanted certain items given to the court before I make a decision on whether or not to grant the defense's motion. My understanding is that the state, you're in agreement with the defense's motion?
That is correct. We have no objection to the motion.
So the court wanted proof that the Child Protective Services case was closed, or there was no concern from the worker defense. Our systems are down. You're an officer of the court. Can you tell the court, do you have that information?
Yes, Your Honor. I believe I'd actually forwarded to Your Honor via email. And in addition to that, a statement from the biological mother of the involved child, wherein she expressed to the court that she had no concerns or reservations with Mr. Rodriguez being unsupervised with her child.
All right. And have the visits been supervised prior to this?
Yes, Your Honor, they have.
All right. And how old is the child?
Eric, can you help us with that?
He's 12 right now.
He's 12?
Yes, ma'am.
All right. So I believe and there's some sort of child custody arrangement?
That I'm not 100% sure. That's my understanding, but perhaps defense or Mr. Rodriguez can speak to that.
All right. Defense, is there a child custody arrangement?
Mr. Rodriguez, could you answer that question? Is there a court
You want to raise
order?
your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Eric Rodriguez.
All right, is there some sort of custody agreement, legal custody agreement between you and the child's mother?
Yes, ma'am. We have joint custody. I get them every other week.
Every other week?
Yes, ma'am.
Okay. And can you tell me, was the custody arrangement in place before or after the alleged incident that you're here for?
It was before the incident.
All right, so after the alleged incident, were there changes in the custody agreement?
No, ma'am.
All right, but there was Child Protective Services involved?
Yes, ma'am.
All right. And Child Protective Services, did they have you do some sort of service plan or no?
No, ma'am.
All right. But did they interview you? What did Child Protective Services do?
Yes, ma'am. They interviewed me, my child, my family, and it was closed the next day.
All right.
Your Honor, I believe Child Protective Services made the decision to close the file back in 2021. I don't know the exact date, but it occurred very early on. And there was no motions to modify the court order possession order by the mother because she had no concerns.
All right. Well, I will tell you this, if you all will write an order, the court then will sign the order and grant it. There are no orders attached to your motion for some reason. I believe that's another Odyssey glitch.
Well, Your Honor, I believe we had the order in back offices but I just don't know where the order actually ended up. Because it was before the file actually made it to the court.
They're somewhere in Odyssey.
Oh, okay.
We'll regenerate an order, Judge.
Oh, yes.
With,
And I don't need the entire motion, just an order. And if you can send it to me, and you can send it to my email.
Okay.
And well, actually, send it to the coordinator's email.
Will do.
And I'll put it in the chat.
Okay, Judge Simpson
There's no
is
dot
back.
in your
Thank
email,
you
Lisa.
to
Sorry.
Jennifer. So we will finish watching this
Now,
particular
then the
case.
next thing we need to take
Then
up
we will jump over.
is the motion for continuance.
Yes, Your Honor. This case went first to the trial court, obviously, the 226 then, and a motion to suppress was granted. The state appealed that decision to the fourth court, which affirmed. There was 4 issues that were before the fourth court of appeals, and the decision was to affirm the trial court's ruling. The state appealed the fourth court's decision to the Court of Criminal Appeals, and the Court of Criminal Appeals dealt with one issue and one issue only, and specifically said in its ruling that it left the other issues undecided. To be, or basically they didn't deal with them at any way. And for whatever reason, the Court of Criminal Appeals in its order indicated that the file should be sent to the trial court rather than the fourth court of appeals to deal with the remaining issues. Defense counsel that's handling the appeal out of Austin, Mr. Schulman, filed a motion for reconsideration and for clarity as to where the Court of Criminal Appeals is directing the file to be sent to. And there's been no decision on that motion as of today.
All right. And when was that motion filed with the fourth court? If you know, approximately.
With the fourth court or the decision?
I'm sorry, the Court of Criminal Appeals.
I believe that was. I'm looking it up on my computer, Judge. Give me 1 second.
No problem.
Okay. Apparently, Judge Simpson was only on for a few minutes, and then he was back into the recess mode. So we will wait until there's a full half hour of Judge Simpson, and then we will go over and watch Judge Simpson. But for now, Judge Boyd, perfectly okay. All right, let's skip ahead.
Looks like May 15th, Judge.
Okay.
The decision was delivered on May 14th of 2025, and I received a copy of that through defense or appellate counsel on May 15th of 2025.
And what is his request from the fourth court, please? For clarification?
No, the motion for reconsideration was filed with the Court of Criminal Appeals.
Oh, so he's filed a motion to
For
reconsider?
Exactly, yes, and for clarification on the directive or the mandate as to where the case is to be sent to for further action.
All right, this is what we're gonna do. Ms. Ferguson, on this case, if you can give them a 60-day reset. And I won't, even though our work is being graded on how we move cases, I'm not gonna charge either of you with a continuance use, because I know that one, your client does need clarification. And if there's a request from clarification from the higher courts, then that needs to be done before this case really moves on. So 60-day reset, please. All right, so we'll be back on September 11th. And while this case is working its way through the system, if you all can make sure that all discovery is completed.
Of course.
All right,
Yes,
is there anything else, counsel?
No, Your Honor, I'll work on that order and send it to Mr. Spear for review and signature that he's agreeable with the language, and we'll forward it to your clerk.
All right, thank you.
Thank you.
You can put it as a discovery.
Are we
All right,
excused, Judge?
You're excused. Once you sign the reset form, you will be excused. Thank you for dressing appropriately for court.
Yes, ma'am. Thank you.
Thank you. Thank you,
Yep.
Mr. Cavazos.
Thank you, ma'am.
That's appropriate.
Yes.
That's appropriate.
All right, who's on here on Anthony Jacob Herrera? Hi, where's your client? Oh, he needs to come up.
He's coming.
Yeah, no, he's just sitting there. People, sometimes they don't want to be a part of their own case. I'm like, come forward.
Good morning, Your Honor.
Good morning. All right, State, were you able to tender an offer?
Judge, so I previously came before this court and erroneously said that discovery was complete, and conferring with Mr. Arglios and reviewing the case myself. This case was done in conjunction with some federal officers, and it looks like some of the federal discovery is missing, and so I need to draft a treaty letter to obtain that evidence.
How did you not know this a month ago?
Plus 30 days.
All right. All right, I need a 30-day reset on Anthony Herrera, please.
Thank you.
No, you need to know what your day is.
Oh, no.
Do you want to know? Maybe you don't want to know.
I think it's like August 19th.
All right, it's August 19th. Just have a seat and they'll give you a reset form and then you're excused. Thank you for dressing appropriately for court.
Thank you.
You're welcome.
It's on. The page is right now, Thursday, in the afternoon, so I can hold on to it.
Go back and after.
Yes.
That's no problem.
Is he in jail?
No.
Is he here?
No.
They have to be.
No.
Or have them.
All right, I think we can skip ahead until the next case. Yep, there it is.
Okay.
There's a motion for early termination. I have to ask for a reset.
Okay.
Another reset. This is not uncommon with resets. Most of these are preliminary hearings or you're scheduling.
Yeah.
You can be my only stop that morning. I can come here first.
All right. And we already have something on July 30th? All right, we'll put you on July 30th.
Okay.
And we'll take this up first.
It's not next Wednesday, but following.
All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court. Thank you.
Thanks, Judge.
You're welcome.
Okay, that was just a rescheduling. Next case.
Escobedo, is the court and counsel, hi, are you retained?
I am not, Judge.
You're appointed?
I am.
All right. Mr. Escobedo, is the court's understanding, based upon the council's motion to the withdrawal, you want to hire an attorney? All right, you have 2 weeks to get an attorney. If not, this will be your attorney. And you can speak to him or not speak to him. That's completely up to you. If you go to trial, you will go to a trial with an attorney you have not spoken to. But he's been your attorney since April. So 2 weeks, you need to have your new attorney here if you're planning on hiring one. Ms. Ferguson, I need a 2-week reset.
July 29th.
And state
Yes.
and defense, do you have all of the discovery?
Yes, Judge.
All right, if you can do an acknowledgement of discovery for me, the system's down.
It is.
So it's down. Were you able to tender an offer?
Not today, but I can get one.
All right. All right, so if you'll tender an offer today, and July 30th, I'm sorry, July 29th will also be your plea deadline date. All right, once you sign the reset form, you're excused.
Okay.
All right, and they will give you an offer, counsel.
Okay. He is trying to get a new attorney, so rescheduling.
Let me just tell you, the other courtroom you were in, was it a district court? All right.
Okay, so that'll come up to you. So you get that.
Okay, next one.
Who's the attorney for Sylvia Noriega?
Hey, so Mr. Glitter.
All right. All right, why are you winking at me? You winked from the side. Here's the thing. Here's the thing. We are not on that level, so don't come at me. Do not come at me on that level. We're not on that level.
Quiet.
All right, you want to take him?
Take him.
Yeah.
Oh, yeah. Now you're in big
All
trouble.
right. I don't understand. Why are people winking at me? We're not on that level. All right, Sylvia Noriega? Yes.
This was a motion to adjudicate things we set a couple of weeks ago. We said it. to
Folks,
see if-
do not for a second Judge Boyd being nice does not mean that she will accept that kind of crap in a courtroom. No winking, no nudging, no nothing. Oh, he's in trouble. I mean, you were there for a reason, sir. Because of alleged crime. The previous one who was going to hire his own attorney. Yeah. Not acceptable.
The restitution had gone to the alleged victim.
Yes.
And that's what we are now. Been on deferred, I believe, for about 10 years.
So were you able to pay any restitution?
Well, I haven't paid any money yet because I was waiting to see what was gonna happen.
You have a motion to revoke because you haven't paid any restitution. What's going to happen is if you don't pay restitution, and it appears based upon what you've told me that you have money to pay restitution, but you're trying to see what's going to happen and hedge your bets. So we can go forward on the motion. Do you want to go forward on the motion to revoke today, counsel?
No, Judge, I think the issue is she's paid restitution, but we don't know regarding the probation, if all the restitution has gone to the alleged victim or if it's going to probation. I think that's what the issue was the last time we were in court.
All right.
Unfortunately, today, because the system is down, probation's unable to look at information.
Are you able to come back this afternoon?
What time?
We can have her back at 1:30 and we can see if the systems are up.
Would I be able to do it by Zoom or would you?
Yes, you can do it by Zoom. Well, you know what, let's not say 1:30 because we have trial that starts at 1:30. I tell you what, we'll recall it for tomorrow and for restitution issues. And if your client wants to appear by Zoom, she can appear by Zoom because it's a matter of restitution. And then if there's an issue, we can always reset it for a contested MTR if that's what needs to be done. All right?
Yes, ma'am. Thank you.
All right, so make sure though that you save some money in case they say that you owe restitution, okay?
Yes, ma'am.
All right, do you have any questions about anything? Thank you for dressing appropriately for court and being on time. All right, once you sign the reset form, you're excused.
Oh, she was lucky there. Yeah, I mean, I've been watching a lot of Judge Boyd the past 6 months. And sometimes these things happen where somebody is, oh, maybe if I ask to a lesser, I will get a lesser, so I stop paying until that judgment is in. And then it goes, no, now you're in violation of your bond instead. So pay, and you can always get you paid enough. Off you fuck. But don't stop paying just because you're hoping that something will happen. Now she was in luck that the system is down. So now she has until tomorrow to, money. Let's see if the winky, with the winker comes back, because let's skip to skip to the next case. Please, George Simpson, put your
Everything is
Oh, that was horrible.
And Miss,
I'm going to
Gordon
cut
Layton
that
on
thing
Zoom.
out of my stream
In Zoom.
for the replay crew, because
We
nah,
just
I
call
don't
this
want
under
that
replay.
on my channel.
All right. Court does call the case of Arbor One West versus Rico
Arbor One.
McGuire et al.
Folks, Arbor One is an area in Ann Arbor. It's infamously bad. It's a proper slumlord landlord case. I have watched a number of them. I have posted on my other channel the Arbor One thing, and on my main channel about the Arbor One slumlord case. It is infuriating. A series of apartments and homes that were neglected for years with black mold, rodents, cockroach. So people had to be more or less, the buildings were more or less condemned until they did all the things to it, hired stuff and everything. And it's infuriating. And they are now trying to fight because the rent money has been put in escrow until the cases are done. In which case, depending on the outcome, the money will be paid back to the tenants. And of course, the Arbor One landlord are fighting this in court and have been doing that for quite some time. I mean, I think one of the first react to Judge Simpson I did on this channel was an Arbor One case, and that was way back in February. This has been going on for well over a year, and it's infuriating. Absolutely infuriating.
Alice Friedman for the plaintiff.
Good morning, Your Honor. Min Kim on behalf of some of the tenants. Rico McGuire. Yes.
Good morning, Your Honor. Debney Gordon Lehman here on behalf of the plaintiff as well.
I appreciate you coming. I set this hearing, I think, to resolve this order. Ms. Kim brought to our attention that an order had come to the court for my signature, I think under the 7-day rule after a hearing. I guess this was back in March after a hearing. I never got this order. It never came down to chambers for my signature. The only way that I knew that this existed, and I'll be honest with you, I was furious that it had not gotten to me, was when Ms. Kim, I think, sent an email asking about that order. So I set the hearing to see if I could enter this order, and certainly to make a record of why the court didn't sign it, because I would have signed it because I think it reflects my order at the time. Given the posture of the Arbor One cases, I am going to decline to enter this order because I think the subject matter of the orders are now before the circuit court. If that makes any sense.
That's our position.
Yes, we agree, Your Honor.
Your Honor, I think it was just clarifying a prior order of yours, and wouldn't the fact that you ordered it at the time before the circuit court had jurisdiction, wouldn't, even though it hadn't been signed yet, wouldn't the court, since the court issued that order on the bench before the circuit court had jurisdiction, wouldn't the court still be signing it just to record what happened in the court?
Well, no. I mean, I wouldn't just sign it to say what happened with the court. That's why we have record, both video as well as transcripts, to say what I said at the time. I think the problem becomes that if I enter this order today, I think, number one, I'm not sure that I can, because I believe that the circuit court has jurisdiction over some of these issues that I was addressing at the time. And I think it will cause a great deal of confusion, especially since I believe Judge Kunke has ruled on relocation assistance and how that's paid for and how that's to occur, which, had I entered this in March, but then Judge Kunke entered something else, that would be the order that would apply anyway. Her order would apply.
I don't think they conflict, Your Honor. And with regard to the first provision about the condemnations not being uncondemned because of the appeal, is the court taking a different position now?
I don't think I have a position now. I mean, right as we sit here today, I do not have a position on it because it's not with me. I can tell you in March, I certainly had a position on it,
If you
which
recall,
is what that is. But as of today, I don't know that that's the case. And I don't know what, I really don't know what Judge Kunke has ruled at each of the hearings, which is why I'm reluctant to enter this.
So compound matters, there's a federal matter that's pending, and the federal court has asked that the parties work on trying to come to a global resolution. So this would further.
What do you mean a federal?
There's a federal case pending. Is that not correct?
that was filed
Deputy?
some time ago, Your Honor, before the circuit court case.
So there's 3 pending cases at this time. The matters before you, Your Honor. There's the matter that the prosecutor and the city have filed against Arbor One before Judge Kunke. And then Arbor One has also filed a federal case before against the city that was filed prior to the case
Yes,
filed by the city.
okay. I think I was aware of.
So yes, that's
I
what
think I
Mr.
was aware of that.
Yes.
Although there wasn't much discussion before me about that, but I think I was aware of that, or at least heard it.
Right, so
So-
Mr. Friedman is referring to is Judge Lightman has requested that the parties meet on, the city and Arbor One meet on Friday to discuss the concept of mediation. He specifically spoke with Judge Kunke about this, and the idea is to discuss on Friday some sort of process for moving forward with a global mediation or just moving forward with the federal case. We're not sure what that will be, but that conversation is happening Friday with Judge Lightman. So I agree, entering some sort of order that would, in essence, I would say go against what, or kind of interject with Judge Kunke's doing in her court at this time could just convolute the process even more than it already is.
I think it just confuses it. I also, and again, it angers me that I didn't get it, but I now trying to enter an order basically 4 months after the fact, that as to some of the issues I no longer have jurisdiction over, I'm just not going to do that. So I'm not going to enter an order.
Thank you.
If you want, Ms. Kim, so that the record's clear, I would certainly sign an order from today's hearing, which would indicate that the 7-day order, it would specifically have to indicate that while filed with the court, it was never sent to chambers for my signature, that the judge was unaware, that upon becoming aware that I set this hearing, and given the issues involved and the other matters that are pending before the circuit court, that the court at this time is declining to enter that order. And then I think it makes it clear as to what I'm doing and or not doing.
Thank you, Your Honor.
All right.
Understood, Your Honor. I just want to bring to the court's attention that this isn't the first, I mean, this isn't the only time. There was another 7-day order that was presented and not given to the court till I followed up with the order later.
Oh, Miss
Okay.
Kim, I am very well aware, and the only thing that did when I got this one was take my temperature to another level. Other people have to get those to me. I can't presume they exist. And they fell down on the job. That's all that I can tell you.
Well, I was just wondering if maybe we should copy somebody else in addition to the clerk of the court in the future with the 7-day or no?
You know, you can do that. For your protection, maybe you should do that, or just send it maybe to my chambers like 10 days after or something along those lines. But the bottom line reality is people have to do their jobs. I mean, the rule, yeah, we can all go around it, but the bottom line is somebody has to do their job to get it to me. And they did twice that I'm aware of. So whatever way you, and that was very flippant of me to say it that way, Ms. Kim, because I do take this seriously. Whatever way you see as being able to protect your interest in making sure orders get entered, I think you know how I operate. However you get it to us, I'll take care of it, my staff, and we'll try to deal with it.
Thank you, Your Honor.
I hate setting up a different process because people don't do their job, but you got to do what you got to do. All right.
Thank you, Your Honor.
Thank you, folks.
Yeah, this is the problem with the Arbor One case, is that so many people, so many tenants have a case against the Arbor One slumlords. It is also a federal case against the Arbor One slumlords. There is so, and things, since people were forced to move, they moved out of jurisdiction, which makes it even more difficult. So not every Arbor One case is in front of Judge Simpson. So there are federal case and different district courts involved in this, which makes this an absolute clusterfuck for everybody involved. And some of the tenants have chosen to have attorneys that may or may not be not so serious. So yeah, it is an absolute clusterfuck. It's wow. All right. I will not return to Judge Boyd as long as that case is going on. And by all accounts, she won't be done with that until that trial starts for her in the afternoon. And that trial is several days in. There's no way for me to get caught up. But I have another one. This is Judge Raquel West and her court. This is in the 252nd District Court, which is in let's see here. It's also in Texas. Jefferson County, Texas. Oh, it's over. Yeah, but I want to hear something fun instead. And the Judge Raquel West in Jefferson County, Texas, I've seen her before, and usually it is very effective. Now she's good looking, and sometimes defendant thinks, "Oh, let me flirt." Yeah, wrong choice. Absolutely wrong choice. Of what I've seen of her, she is on the level of both Judge Simpson and Judge Boyd. She does not take crap from anyone. So let's move on to Judge West.
Okay, so is EMS coming or are they already here? Yeah, okay. Okay, Mr. Nichols, Mr. Franklin on Juan Sanchez. Good morning.
Okay, let's see here. Okay. Judge Boyd sentenced him to the agreed upon penalty, 12 years, including time served. And he's been incarcerated for 2 years, so 10 more years. Well, at least he's off the street for 10 years. And with some luck, due to natural causes, he will never get out of prison. Jesus Christ, that case was weird. Oh, it was. And also, if they had brought that to trial, perhaps it would have been the maximum of everything. But then again, the girl is now 16. Yeah. Ugh. She basically said she would have given him more, but his lawyer did a great job. Yeah. Ugh. Yeah, 12 years seems to be not the max, but that was the plea agreement in that case. But I want to forget that case. Let's get on with this case instead.
Good morning. All right, this is cause number 1830854. And sir, you're Juan Sanchez? Yes. And so we're here today on a motion to compel. And before we get into a whole lot, I've done a lot of my own research and looking at all of this. And a couple of things. One, I don't believe the subpoena ducis tecum was the proper way to try to get the information. Ducis tecum is an order to get somebody to bring something to a set hearing. So but we didn't have a set hearing, and they weren't ordered to give it to at a set time for a hearing. So under the rules that have to do with subpoena ducis tecum, I don't know that that was the proper way. I do think you're entitled to some of that information as a defense attorney. If we're going to base decisions on, if I'm going to base decisions on things that probation have in their file and that they're just going to tell us, I do believe that you are entitled to some of that information. I think the proper way to do it would be to make that request through the district attorney's office for discovery. And then for you, Mr. Nichols, to make those requests. And then I would approve you guys giving whatever records are requested within reason. If you have, I don't know what would necessarily be any type of work product that would not be discoverable, but if you think that there's something that is particularly not discoverable, let Mr. Nichols know that. Mr. Nichols let me know that. Then we could worry about maybe a motion to compel and whether or not I think those things are or are not. But lab results of testing, money owed, all of those types of things, I think are probably discoverable and something that Mr. Franklin needs. I just don't think this was the.
I agree, Judge. Any of the things that pertain to, well, I do think it's discoverable. In this case, it's all allegations on the motion.
I'll fetch something to drink. I'll be right back.
And so his attendance record and all that, I don't know why we're subpoenaing the entire probation file when it's not even part of the allegations for the motion.
May I respond, Your Honor?
Well, let him finish. Yes.
He did subpoena Wharton County records, so a representative from probation down there came in today for this hearing.
Mhm.
I have no problem with getting him all that stuff. A lot of it's not in my possession. The out-of-county offense reports and things like that, I don't have yet. I would have them if we move towards a hearing where I prove up those allegations, and they, of course, will be provided beforehand.
Mhm.
And again, I don't think he's not entitled to have all that stuff. So
Sure.
I kind of agree with
So-
you. I don't want to subpoena directly to those agencies was the proper way to do this. And Mr. Franklin did make just a standard discovery request at the onset of his involvement, which was early May. I don't have anything really responsive to that at this point.
Okay. So obviously, if it's based on a new offense out of another county, that's something you'll need to work towards getting and get that to Mr. Franklin. And so that needs to take place as quickly as possible.
Hi, Isabel.
Let me look at the
Thank you
motion
so much.
itself.
Yes, we're still here.
Because I don't know, I guess, Mr. Franklin, if there's not an allegation in the motion to revoke with regard to certain administrative violations, and there isn't an allegation, then why would you, what is your argument that that would be relevant or discoverable?
Your Honor, my client
Oh, sorry.
is wanting to stay on probation, and the court may
Thank
take
you,
into
Isabel.
consideration his performance while on probation, including
We are still here.
his payments, his
Port jumping.
support, and everything else. So as part of determining the motion to revoke, it is relevant to look at his performance while on probation, particularly when he is requesting to stay on it. And he's been on probation nearly 6 years, I think over 5.5 years, nearly 6 years. And that performance will be helpful in determining or mitigating whether he stays on probation or if the court decides that he goes off of probation, and perhaps mitigating any potential sentence.
Okay.
And
I don't
so-
disagree. I don't disagree. So, again, though, I think the way to do it would be to make that request. I mean, and I don't know what conversations y'all have had, but make the request. I think coming at it aggressively might not be the way to do it. Sometimes you get more with honey than otherwise. So make the request to Mr. Nichols. If he says no, then let's go through what we need to go through. But let's try to do this amenably. The ducis tecum is not the way to do it unless it's set for a hearing. That's just the rules of evidence. And
Yes, Your
so
Honor.
that's not the way we're going to do
The
it.
ducis tecum was set for the day that was initially set for a hearing, and it did specify that date before the hearing, I believe. And we ended up moving the hearing date because of conflict.
And Judge, I'd ask Ms. LeBeau to go ahead and get everything together
Yeah.
to turn over.
I mean,
Unless
yeah.
There was something that the court was ordering her not to turn over.
I don't think on this list that there are, I mean, is there anything that y'all specifically had an issue with?
Ms. Long, is there, or do you have any concerns you want
If there's,
to make the court aware of?
Your Honor, just with the clarification of, our departmental chronologicals, which include, anything that pertains to the case that happened, chrono telephone calls, auto-generated, appointments, reminders, office visits, drug tests, anything that we enter into the system. But those are the chronologicals through the probation office, as well as releasing of the jail logs, his sex offender verification, interlock reports, because those were not listed on the subpoena, as well as the offense report through DPS, which was released to me and my under a supervision officer. So just to clarify, as to those items specifically being released that were not listed with the exception of the offense report.
Your Honor, we don't have to list those. We filed a 3914 discovery request. This was belt and suspenders because we didn't get any of the information relating to probation in our 3914 motion originally. I would also note that the chronologicals.
Well, and these aren't, the reason you didn't get any of those is because those aren't his, they're theirs. And so they're not, I don't think Mr. Nichols has the ability legally to make probation give them those. I think once we talk it out though, I think whatever Mr. Nichols, y'all get together, obviously offense report, if y'all have the offense report and you don't even have it, then you need to get, I mean, that's,
Right. I mean,
that's great. Everybody
it's
can
all
get the information in an amenable way. So let's do that. Y'all sit down. I want everything that you have that is, I don't know that there's anything I can think of that would be,
Unless, I mean, I guess
Not-
notes may be work product, but I'm not real.
that's what I'm thinking about, but it's
I'm
not
too
really
concerned.
attorney's notes. And so I don't know that that would
I
be an
would object to
issue.
that, Your Honor.
At least this is a short.
On the grounds it's not attorney work product. It is merely work product of an employee and it is discoverable and relevant to the case.
I'm going to play in
And
1.25.
that's what I just said. You seem very frustrated, and I'm not sure why. I mean, I don't know.
I'm confused by whether there's pushback at all on any request for a 3914 discovery when he's constitutionally allowed to access this file. It should just be produced by probation without a fight. And we got a letter anticipatorily repudiating any production of discovery, and we had to file a motion to compel to that effect.
Well,
And that is alarming to me that we would have to even compel anything under 3914.
This is not something that a lot of attorneys have done in our cases. And so if there is something, if you'll sit around and watch today how everybody gets along, hold on.
Yes,
And the last thing you want to do is talk over me.
Yes, Your Honor.
So I'm sitting here saying that I agree with you, and you're still being argumentative even towards me. And that's not going to get you anywhere. Hold on. Being argumentative with Mr. Nichols isn't going to help Mr. Sanchez. Being argumentative with these ladies isn't going to get you anywhere. I agree that you're entitled to this information. I just think there's a better, less argumentative, defensive way to do it. They were told to do what they were told to do because their understanding of the law is what it is. So I don't disagree that we needed to all get together, but it just needs to be taken down a notch. So I want the stuff turned over to Mr. Nichols, and then Mr. Nichols will turn it over as discovery. I'm not going to have probation start turning it over to the individual attorneys in cases, because I think the proper way to make sure it's in the portal, that everybody knows what the discovery is that they've received, so that it's electronic when you sign your any type of documentation, whether it's at a hearing or a plea or a trial of what you've discovered, that it goes through that portal so everybody knows what everybody's got. So y'all get it to Mr. Nichols. Mr. Nichols will put it in the portal, and then you will get it. Once you get that, if there's something that you think is not there, then contact us. We'll have a hearing if necessary. Contact Mr. Nichols. Hey, what about this? If it exists and he says no, then let's have a hearing about it. Okay. So y'all get that done. And then we'll reset the case for just an announcement in what, a couple of weeks or so. Fine with that?
That should be fine, Judge. We'll be able to get everything scanned in and provided through the portal.
Perfect. Thank you. All right. Y'all are all excused. I'm sorry. No, ma'am. If you'll just get what you need to Mr. Nichols, unless you are personally subpoenaed to be here for a hearing. Now, and on that date, we won't have a hearing on that date. So if we come in and there's pleas of not true, and we're going to have a hearing, we can come in on that date, enter pleas of not true or true to certain allegations. Then we would reset it for a court date. And at that point, if you need to be here, let her know. If you need a subpoena, then you can get a subpoena. If you just need us to let you know you need to be here, then we can do it informally. You just let us know, or let Mr. Franklin or Mr. Nichols know what your employer will require for you to be here for an actual hearing. Okay? Good. All right. Thank you, y'all.
Thank you.
Oh, that didn't take long, luckily. Let's see what other cases are on the docket.
Is she back there with, is Brittany back there? Which one? That's on Mr. Miller.
A few months ago, she had a case with a guy who showed up in an appropriate shirt, and she went off on him. He had, large guy, and thought he was in front of a tiny little girl. Oh, he just shrunk and shrunk and shrunk, and he had no worth whatsoever when she was done with him. Oh, it was amazing to see. Nobody fucks with Judge Raquel West.
Thank you.
Yeah, and Judge Raquel West
Good morning.
is in 252nd District Court in Jefferson County, Texas. So we're still south.
Mr. Coleman, we're going to take care of Mr. Miller. It's a competency. All right, this is cause number 241916. And are you Edward Miller? Good morning. And so Mr. Miller was evaluated by Dr. Hamza for competency to stand trial. I received that report dated June 26th of 2025. The finding in that report is that Mr. Miller is not competent to stand trial. Is there any other evidence with regard to competency? Ms. Holmes?
No.
And then at this time, I am going to find that Mr. Miller is not competent to stand trial, that inpatient treatment is required for competency restoration. Order you to the appropriate facility. This is just to get you some help, Mr. Miller, okay? And we're going to get you some help, and then we're going to get you back in here. And it'll be for a period of not to exceed 120 days from the date that he gets to the appropriate facility. All right, you can go back with the bailiff.
Remind me, we added that on the guy from yesterday, the flight. Charlie.
Oh.
It's not on the docket anywhere, that's why.
And what was it said?
It's just
An announcement?
Yeah.
What?
Yeah, for you who don't know, Judge West graduated from the St. Mary's University in 1995, which would make her one of the youngest attorneys graduated in history, because she looks late 30s, early 40s at the most. She's not in her late 30s or early 40s. Let's just say that.
Oh, okay. But is it on the, is it going to show
Yes,
up
ma'am.
here?
You may have to refresh your calendar, but it's.
Okay, all right. It goes. Yes. So the only other option would be to go through the civil, go through a civil commitment would be an option. And so if you get that done, the case can get dismissed, and then he can go a different route. But you have to get with your people on how to do that. I know Ms. Mulkino's done it on some, but it. I mean, if it's, obviously there's some issues that need to be taken care of. So perhaps we get the initial competency restoration done and then do it at that time. Yeah. Yeah, how did that feel coming? Oh my gosh, I got so mad that I'm shaking still. Like, I haven't been that frustrated in a long time.
She was elected
Mr. Kimler,
judge.
you have Reagan Howard.
She was elected judge in 2014, so she's been at the bench for 11 years.
Don't do well with that stance.
Mr. Smith and I are getting along now.
Thank y'all very much. Appreciate that.
There's not a bit of old friends.
That's an interesting way to start the morning.
She'll play true or not true, then I'll ask her one. And she did have an email first.
Good morning, ma'am. You're Reagan Howard.
Yes, ma'am.
Ms. Howard, would you please raise your right hand? Best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you put your hand down. Let me get this. And she's just going to plead to the motion.
Yes, ma'am. Yes, Your Honor. And get it up to the side. Mr. Smith. There may be evidence he wants to put on that here.
Okay. All right. Let me get this. Ms. Howard, in cause number 22-39924, I have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation June 10th of 2024 for the third-degree felony offense of deadly conduct discharging a firearm, and that was a 6-year deferred probation. Is that correct?
Yes, ma'am.
And then it alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department October 7th and November 1st of 2024. And is that true or not true? The dates were October 7th and November 1st of last year, 2024, that you did not report. Is that true?
Yes, ma'am.
Okay. Count 2 alleges that you're behind in your court assessed fees. And is that true or not true? Count 3 alleges that you also failed to report June 27th, August 21st, and September 24th of 2024 to the probation department. Is that true or not true?
Yes, ma'am.
Uh-oh.
Count 4 alleges that you failed to work faithfully at suitable employment and provide verification of that to probation. And is that true or not true?
That's true.
Count 5 alleges that you failed to immediately report your contact information as ordered to the probation department. Is that true or not true?
Yes, sir.
Count 6 alleges you provided a urine sample August 27th of 2024 that tested positive for alcohol. Is that true or not true? Count 7. So count 7 alleges that on that same date of August 27th of 2024, you also tested positive for cocaine. Is that true or not true? And then count 8 alleges on that same date, you also tested positive for tetrahydrocannabinol. And is that true or not true? Count 9 alleges that you did not provide verification of performing the community services
She
required. Is that
violated
true or not true?
everything.
Count 10 alleges that you did not provide verification of entering and successfully completing the anger management program. Is that true or not true?
Not true. I didn't get assigned to anger management.
Okay. Count 11 says that you did not submit to alcohol or drug screening September 9th and September 16th as and then apparently you had possessed a device or an object for the purposes of providing a fake specimen. Is that true or not true?
Not true.
Count 12 alleges, again, that you're behind in your court assessed fees. This was done a little bit later, so the amount is more. Is that true or not true?
True.
And then count 13 alleges that you didn't provide verification of entering and successfully completing the moral recognition therapy, the MRT program. Is that true or not true? Did you enter your pleas of truth to counts 1 through 9 and then 12 and 13 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to those counts freely and voluntarily, find them true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to reset your case for a sentencing hearing. And we'll get an updated pre-sentence report done. And if at that time the state wishes to put any evidence on with regard to counts 10 and 11, they can do so. And then anything that you think is important for me to know at that time, get that information to Mr. Kimler. He'll present it to me on your behalf when we come back. And this is unagreed. Jody. Okay, all right.
Your Honor, we had asked for a bond. I think if the court would set a reasonable bond,
Reasonable bond?
To post that bond, she would be able to demonstrate to the court.
That's denied. I'm going to find at this time it is in the best interest of our community and under the Article 1517 that even though this is a deferred probation, based on the nature of the underlying offense, which is a deadly conduct discharging a firearm, the fact that it looks like Ms. Howard has done pretty much nothing, including not reporting while she's on probation, and when she did test positive, that it is not safe at this point until I have more information for her to be out. So that's denied.
Boom.
You do have her.
Yes, and I've already received those, and we'll get those to probation as well so that they can be part of that pre-sentence report. Okay, you can go back with the, what's that? Well, I don't know right now until we come back for sentencing. So probation will come talk to you, talk to Mr. Kimler. I'll get all the information about what's been going on, and then I'll make a decision when you come back about whether I keep you on probation, revoke your probation, keep you on probation, send you somewhere for treatment. It just depends on the information I get when we come back, okay? Okay, you can go back with the bailiff.
Beautiful. Folks, I've been on for 4.5 hours, and now I realize I have not had my tip jar up. Yeah, I'm boomering gratefully. Boomering gratefully. I have my tip jar up if you want to support this channel financially. Never necessary, only deeply appreciated. Do not ever donate or gift what you don't have. I forbid you to gift if you are struggling. Okay? But if you can, if you have the means, I would deeply appreciate it. It is via PayPal. It's pinned on the top of the chat. Thank you. Let's continue. Oh, and
Mr. Matuska, you got Von Zell Hall.
And thank you to Isabel Park who bought me a coffee. Yes, I also have buy me a coffee as a means for support. Everything you can see in the description below.
Good morning.
Or if you buy any other choice, you can always watch my videos, which has ads in
Good morning, you're Von Zell Hall. And in 24-1747, Mr. Hall is charged with murder. And what is the announcement?
The last setting requested some digital media. Since then, Mr. Nichols has done an impressive job providing most everything I need. Unfortunately, I think some of it hasn't been provided to him. I've discussed this with him. I'm trying to get a few more items I think are pretty important to the situation before we announce. If I could have him a 30-day reset.
There was some follow-up testing and some documentation that he was asking that I don't see in my file, so we need to find out if it exists, where it is, and things like that. So.
All right, so I'll do one more reset. Y'all can work on that. If there's anything that you can get, obviously get that to Mr. Matuska and Mr. Hall. Mr. Matuska will be out there, I'm sure, to visit with you once he gets everything to see what y'all want to do at the next court date, okay? All right, you can go back with the bailiff. Thank you.
Your Honor, I've discussed all with him already.
I figure. Thank you. We're impressive. You've done an impressive.
Well, that was a good thing.
That was a lot, but that's okay. We appreciate that this morning. We're resetting both of Mr. Radford's cases this morning. So Lenny Leday and Traylon Martin. Okay.
Cody Dent, one was hired on two of the cases, and Marvin and some other.
Yes, I saw that, Isabel. Thank you so much.
So I put him in the
I deeply appreciate it.
Okay.
Thank you so much for buying me a coffee.
Okay. And we reset Joel's, correct?
Yes.
That's yes. I just so I can get a break. Mr. Rojas on Anthony Williams. Good morning. You're Anthony Williams. And Mr. Rojas, will your client waive the formal reading of the indictment?
Here we are.
Mr. Williams, in cause number 240401, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from December 7th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement is for a 10-year term in prison, but that would be probated. You'd be on probation for 7 years. There's a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Sir, state tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that I can get a pre-sentence report done. That'll give me more information about you and your case, and then we'll come back at a later date for sentencing. You need to stop and talk to probation on your way out of the courtroom today so they can start that report, and she's sitting at that desk right over there. All right, we'll see you back at sentencing. Yes, sir. Mr. Rojas, you have there in Jackson.
Yeah, so yeah, that happens. People show up not looking so well, which kind of is one of the downsides of allegedly committing crimes and being in jail.
Good morning, you're there in Jackson. And Mr. Jackson was previously in court, entered pleas of true to counts 1 through 5 in each of his motion to revoke unadjudicated probations, on probation for aggravated robbery. Actually, 3 cases, an aggravated robbery and then 2 aggravated assaults with deadly weapons, in cause numbers 24-1324, 1323, and 0883. I've received the updated pre-sentence report. This was unagreed, and has everyone had an opportunity to receive that report and review it?
We have, Your Honor.
Are there any additions or corrections to that report? All right, Mr. Rojas, you may proceed.
Judge, Mr. Jackson recognizes he's on probation for some serious offenses. And that, in my opinion, it's like he needs help. The main problems come from mental health issues. He's homelessness, he's got lack of transportation, and he's got limited family here in the area. He tells me that when he was first released from jail, he didn't have a place to live, didn't have any transportation. That's the reason for not being able to get to probation department in the beginning. He's been on probation for such a short period of time. He's been unable to get the benefit of the resources that probation has to offer. I understand that's because of his not attending probation. But again, I think that all stems from the homelessness and the lack of transportation and the mental health issues. He is trying to get help for himself. He does have the application to get his government benefits. He's got a contact with someone from MHMR if he were allowed to stay on probation. He tells me that he has a place to live now. He's going to be living with his cousin who does live here in Beaumont. He is hopeful that he can get his job back at the place he was working for at the barbecue restaurant.
Hold on.
And of course, that all is going to depend on him actually going through probation. And he tells me now that he does understand that the importance of getting there. He will do everything he can to make sure that he does get to probation if the court were to allow him to stay on probation. And that's what he's asking the court to do this morning, Judge. And at the proper time, I think he does have a statement to make.
Go ahead.
Hello, my name is Darren Jackson. I'm writing this letter pleading for mercy. I started my probation off on the wrong note. Everything I had on probation was in first place. I ended up losing my cell phone and the place that I was living. The people found out that I was on probation and they kicked me out the house. And I didn't have, they kicked me out. I got kicked out of the place. I was staying there. And the same night, the police had came.
Thank you, Isabel. Thank you so much.
Some improper, like, some things that I didn't do. And they said I was under intoxication, but I wasn't, you know what I'm saying? Because they was all fighting and stuff like that. And they put me in jail for one night for intoxication, but they didn't have no breathalyzer or nothing saying that I was intoxicated, and they said I was intoxicated, and they was lying. They was lying on me. I don't have, they didn't have any record or proof of intoxication.
First of all, thank you, Isabel. Thank you so much. Deeply appreciate it. And then I got the notification from Katrina for $40 from Turnips. From Turnips. Way! Thank you so much. And folks, for you who don't know, I have this week off. So I think that causes for a celebration. And since we are watching a Texas court, Texas shot glass. Thank you so much. Because, I mean, $40 plus Isabel being generous, Film Freak gifted memberships early in the streams, plus super. I mean, seriously, thank you. Thank you so much. And cheers to you all. Oh. Thank you so much. Thank you so No stringable. Even all the small streams leads to a big river. But thank you so much. Thank you so much, everybody. And again, I will say this probably a bit too much often. I forbid you to give if you're struggling. I forbid you. And if you want to make for a good cause, I can give you the links to the Zachariah Anderson Appeals Fund, to the Turtle Boy Defense Fund, to the Innocence Project or something like that. But if you want to support my channel, I deeply appreciate it. But I specifically forbid you to gift if you're struggling. Okay? What did we drink? Then Old Hare blended whiskey. It's my go-to. No, if I say day-to-day whiskey, it sounds weird, but if it's a nice day out, I sit outside with a cigar and a whiskey of some sort, I'm going with that one. I almost said when I mow the lawn, but of course I would not drink and drive.
I got to jail and they released me the next day for public intoxication. I reported the next day, the day I was supposed to report. You know how they let you out of jail. You know what I'm saying? At like 3 o'clock. It was raining so bad. It was flooding. I didn't have no way to get there. So I walked. The next day I waited till it stopped raining.
And now I saw another from Emily. Thank you so much. If you're still here, Emily, thank you so much. If I only use first name because many times we are PayPal, you have your actual name, and sometimes you don't want me to pronounce the entire name. So just first name. So thank you, Emily, for Emily Stringabell. Yay! Thank you so much. Thank you. Thank you for 549. Thank you. Thank you so much.
And it was unflooded. And I walked to the probation office, and I told the lady that I didn't have my social security card and my ID, and she said she was going to help me do it. I was very excited, Judge. Trying to get my GED. I was very excited about going to school, and man, the lady kicked me out of the house while I was staying there, and I had to move in a hotel room, and I ran out of money, and bro, it just all went downhill from there. Yeah. And if you can find any way for me to get back on probation, I promise I'm gonna do the right thing. And you know, I'm a good citizen, and I help anybody I can. I'm a minister of music. I go to church, Solid Rock, Church of God Christ, and yeah, man, I've been trying to stay out of trouble. I just been running on hard times. I just need a second chance.
Ms. Monfino?
Judge, I'm not unsympathetic to his situation. I don't think it's something that he's just coming in today saying that he's had these problems. I think they've been ongoing. I think that's why we had initially wanted to give him the opportunity of probation so that he could participate in the mental health caseload. Obviously, he's very lucky to have him score as his officer, but I have spoken with her several times about this, and she has gone above and beyond just trying to make contact with him to bring him in to say, these are the resources we try to have to help you, and they just can't ever find it. I'm not suggesting that necessarily my position is revocation, but my position would be, Judge, if the court gives him this opportunity, he does not take advantage of it, and he does not do what Ms. Ford needs him to do, that the court orders him to do, that the recommendation would be significantly higher than it would be today, based on that.
You probably haven't even had enough time to know. I guess my question, Ms. Core, would be, if I continue him on probation, would something like cognitive track of ISF be
Yes, ma'am.
helpful, or that, or either special needs safety? Which one do you think would be more appropriate to help him get a good start before he gets back out?
I would think very highly of the special needs safety for him.
Okay. Okay. I mean, Mr. Jackson, everybody wants you to be successful, but you're the only one that can make that happen. You have all the resources. Ms. Core wants to help you. Probation has all kinds of things to help you, but you have to, they're not going to come, she's not going to come find you. So if I give you this opportunity today, you're going to go get some help in custody. Listen, and when you're out though, and when you're finished with that treatment, it's going to be your responsibility to go where you're supposed to go, to let her know where you're living, and she's not going to go try to find you. You don't show up, then you're going to be back in here, and we will not be having these conversations. Today, I could send you to prison for the rest of your life for violating your probation right now today, for life, for 50 years, for 30 years, for 20 years, an aggravated robbery and 2 aggravated assaults with deadly weapons. You should probably be going to prison. So you need to understand that this is it. There's no second chance. This is your chance. All right. So I'm going to find that you entered your pleas of true to counts 1 through 5 in all 3 cases freely and voluntarily. Find those counts true. Find sufficient evidence in each case to revoke your probations and find you guilty, but I'm not going to do that. I'm going to continue your probations in each of your cases. I'm going to order in each of your cases that you enter and successfully complete the special needs track of SafeP. That's going to give you all kinds of help to make sure when you get out, you're ready to go and you'll be making better decisions. You won't have any issues, hopefully, with regard to any type of drug or alcohol abuse, and you will also have aftercare, a place to live, and things like that. So you're going to have what you need, and it's going to be up to you. All right. Good luck to you, sir. You can go back with the bailiff. Thank you, Mr. Warren. Ashley Faye, Mr. Rojas. Good morning.
Judge, we think we can do this. She does 3 prior state jail felonies on the same day. They're not sequenced, but I think we can still do a 3rd degree.
Yeah, they don't have to be sequenced. Only regular ones to make it a 2nd degree have to be sequenced. That's our old drug court days. Toby, you should remember that.
But I looked at them when they're all the same day.
Yeah, I remember that from those days. Okay, so she's gonna go. Let me say this the right way.
The audit sheet's been in, Judge.
Thank you. Good morning. Are you Ashley Faye? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Faye, in cause number 250355, you are charged with the state jail felony offense of credit or debit card abuse from October 16th of 2024. Your indictment alleges that you were previously convicted of theft, a state jail felony, March 15th of 2019, in 3 different state jail felony cases of theft on that same date. And how do you plead to the charge? And are those prior theft convictions true? Answer out loud, please. Did you enter your plea of guilty and true freely and voluntarily? And because you actually did what they've charged you with. I have here on the computer some documents that have your signature on them, but the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes, ma'am.
Do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you not understand something?
No, I kind of wanted to ask for probation.
So this isn't where you do that. Y'all have negotiated with Mr. Rojas. Mr. Rojas negotiates with Mr. Hoffpower. They do all of that. I don't get involved in that process. So there's a couple of things you can do.
Is his name Half Power? That's an interesting choice.
You can go ahead, Mr. Rojas.
So we did have an offer for a cab judge. We talked about that, and this is the one that she chose. If you have a second thought, we can talk about that some more.
Do you want to go talk to Mr. Rojas about that cap? The cap would be pleading open to me, where I could give you time in prison. I could give you probation. It would depend on all the information that I was given at a later hearing for a sentencing hearing. If you want to do that, then you do want to do that. I think you're going to have to do the unagreed, the different. No, you're not. With everybody's permission, I can make those changes on this. What is it? Cap of what?
Cap of 5.
How do I? No, it's not. It's writing with it. So I'm just scribbling on it. So on the agreed punishment recommendation page, I am marking off the cap of 5. And then I think that's really the only thing that needs to be changed. Okay, so then let's go back. The agreement that you've reached is for a cap of 5 years. And I want to make sure you understand, it sounds like you've gone over it with Mr. Rojas, that what that means is that you're leaving your punishment up to me. As long as I give you 5 years or less, I can consider probation, you cannot appeal. Do you understand? And you have an absolute right to have a jury come in and determine if you're guilty or not. You can leave your punishment up to a jury. If we go forward this way, you're waiving that right. And is that what you want to do? Right. Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence in this phase not competent?
Oh, yeah.
All right, ma'am, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so the probation department can do a report that'll give me more information about you, your history, your cases, and then we'll come back for sentencing. Anything that you think is important for me to know, get that information to Mr. Rojas and he will present it to me on your behalf when we come back. All right, go back with the bailiff. Yes, ma'am. Do you have anything else?
Yeah.
Oh, okay.
Yes, thank you, Isabel. Nick got a lot of accolades when he did the interview with I can't remember who, and I assume you are talking about the $1 billion defamation case, Young versus CNN, where I had Mr. Devin on his defense attorney or his attorney for well over an hour, just talking about the case and future cases, and he got CNN to settle. Now, he already won $5 million in the first part of the defamation trial, and then it was time for the jury to decide, okay, what will go on top of it. And later, a juror said they were talking about in the region of $100 to $200 million in fines towards CNN. But CNN decided to settle, and he wouldn't give me numbers, but I would assure you they did not settle under $50 million. And here's something fun about the Young versus CNN case. Mr. Young is now suing Fox because they took in everything CNN did, and even after the trial, Fox refused to take the articles down, so now he's suing Fox. So that's interesting. Not with the same attorney, but once I find the information, I will give an update on that case as well. I covered the Young versus CNN. When was that? Dun, dun, dun. That was way back in the $1 billion defamation. That was in January of this year. And the interview is from January 26 with Devin Velvel Friedman. Let's see here. Here is the link to that. He works out of Miami, Florida, and hopefully when I get to Miami, September 18, 19, 20, I can have a meeting with him. Yeah, for you who don't know, hi, I'm going to the United States in September. I'm spending September 13 to 18 in Utah, and then a week in Miami. And September 20th, me and Steve Gosney will have a meetup in Miami, somewhere in central Miami, at a bar. Food and bar stuff, food and bar place. So if you have the chance and means, yeah, I would love to have you there.
That's for bond.
That's the one from.
Yes, I will be visiting Jeff in Utah. That is the main reason I'm going to Utah. I'm also meeting up with Connor and Damian.
Of course I did.
And then I will
Sure, I
be
remember that.
traveling around in visiting old Western movie scenery sites.
Oh. Yeah, and okay, but nothing was filed. She just made the request of let's get Janicia Leonard out, and I'll just put it on the record since they. I just decided to, well, and what went on, I don't know if you know, so last week I received a message from Judge,
The jail has a policy in place for that.
Yeah, last year
I'm not concerned about it necessarily.
Last year in August, I went on a road trip from south to north. So I went to Houston, New Orleans, Atlanta, where I visited the YSL trial, that courtroom. I also visited Chattanooga, Knoxville, Delphi, Indiana. I actually went to Delphi, Indiana, and then up to Detroit. And then I flew home again. So I had a 19-day road trip across the United States last year.
Just wanted to put something on the record because she made, I guess, enough impression on Judge DeRuin. And so even without a motion, I just wanted to at least put some stuff on the record. And then obviously if at a certain, I'm not going to set a bond today, but I'm going to explain where we are, why there's not a bond. And then if you want to file something and we have time for a hearing with some specific information, once you kind of get, then I'll reconsider it. But let's just. Yeah, well, there's that. The only thing, the issue, one of the issues I have is the new case. It's from 23. And so actually I might consider a bond just because if she hasn't been arrested since 23. let me look
I
at,
could just have, I mean, I would want 3 days to prepare, but if.
we can reset it for next week. I just want,
If you want to do it today, I'm not going to do it today. My argument with you, Judge, is it follows the same average.
yeah, I just, the length of time, I want to know if she's been doing well on probation other than that. That's one thing I would like to know. And so I think let's reset it for next,
We can reset how.
let's do that. Let's reset it. Tell Sharon, never mind. Let's reset Miss Leonard for next week. And then I would like to have, I think Miss Core already left. Miss Core was her, that's okay for next week. If she can be here, just so that I can, because of the length of time of that new offense allegation and when it was indicted, I think I'll consider that. And that'll give you time also, Mr. Coleman, to see what's going on and what we can do. All right. Thank you. Mr. Samuel, you have Cody Dent.
Yes, Your Honor.
Good morning.
I'll discuss that, so I'll be filing that afterwards.
Okay. If you're requesting, make sure since you're hired, you'll have to do an affidavit of indigency if you're asking the county to pay for anything.
I will.
So make sure you attach that with it. when you
Okay.
do it. Good morning. Are you Cody Dent?
Yes, ma'am.
And Mr. Dent is on probation in 2 cases, 13-17772 and 22-41052 for the offenses of obstruction or retaliation and theft of property. Those both have motion to revoke pending. And then there is a new allegation or new indictment in cause number 250807 of burglary of a building. And Mr. Samuel,
Yes, Your Honor, I've been hired to represent Mr. Dent. I went out and visited with him this past weekend, and I've also spoken with him this morning. And as a result of my evaluation and talking with him, I believe it's merited to have someone appointed to give a professional evaluation. We realize that he is on probation. I realize there is a new charge. This is our first setting. I've not had an opportunity to complete discovery, but I think upon getting the information from discovery, and if we can set for bond hearing at a later date, maybe next week, if possible, we believe that the results of that evaluation will show that there is possibly some alternatives that are available.
so it's set for bond hearing today on those motions, but you want some time to get up to speed on that other case. You want me to put that off? Just hold it?
Yes.
Okay.
Yes.
All right.
At least until next week. I'd like a quick turnaround because right now there is no bond.
Right.
And he needs to get assistance.
Okay. An evaluation won't happen in a week.
I understand.
Okay. So you still think give you a week to get up to speed?
Correct.
Bond hearing next week?
Correct.
And then I'll look at your motion for the evaluation. We'll take care of that.
And I've talked with the prosecutor.
Okay. We'll reset it. How's next week? Are we? Yes. We're good. Okay. We'll reset it for 1 week for a bond hearing on those 2 motions.
Right.
Thank you.
Thank you, Your Honor.
When you're finished, come sit down. So he does need to fill out.
Mr. Lewis on Justin Franklin.
So,
Good morning. Are you Justin Franklin?
Yes, ma'am.
And in cause number 250514, Mr. Franklin's charged with aggravated robbery. Mr. Lewis, what is the announcement?
Well, Judge, I understand the complaint. We have been in touch with the state on this one.
Judge, may I put a few things on the record, please?
Yes, ma'am, of course.
First, may I have the name Kayla Davis called?
Will you call the name Kayla Davis, please?
Okay.
Good morning, ma'am. Are you Kayla Davis? Ms. Malfino, do you need some time maybe to visit with her, or do you want to go ahead? Put something on the record? Okay. Ms. Davis, would you please raise your right hand? Do you swear or affirm the testimony you'll give in this hearing will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Yes, ma'am. Thank you. Go ahead.
Ms. Davis, would you please state your full name for the record? And Ms. Davis, what is your relationship to the defendant, Justin Franklin?
He's my husband.
Okay, and how long have you all been married?
We got married in January.
In January? And you know what we're here about today, right?
Yes.
The aggravated robbery that he's alleged to have committed against you and your children, right?
Yes.
Where he held you all at gunpoint and stole your purse and wallet, right?
He didn't kill us in gunpoint. He didn't steal my purse nor my wallet.
Did you tell the police that that's what happened?
No, ma'am.
So if that's what the offense material reflects, and that's what the grand jury proceeded on with an indictment for aggravated robbery, are you saying under oath to the court today that that did not happen?
Yes.
And you have many times called my office asking that the case be dropped, correct?
Right.
You've come in and signed a non-prosecution affidavit.
Yes, I have.
You have called saying that this did not happen and that you're not going to cooperate with the state,
Yes,
correct?
I have.
Are you in fear of Mr. Franklin?
I'm not.
Is he pressuring you to do this?
No.
And do you understand that if the state does not proceed with this case, that you're taking matters into your own hands?
Yes, I do.
With respect to your safety?
Yes, I do.
And that's what you want me to do?
Yes, drop the case, please.
And you're asking Judge
I'm
West
asking
to allow
Judge
me
West
to drop the case?
Drop the case.
All right. All right. You can step back.
Thank you. And Judge, just for the record, if I may, obviously with those facts, obviously the court is aware of experiences you and I both had in the past. I think there's something more to the incident. She's obviously not going to cooperate with me. She's obviously also his spouse. And so at this time, with the court's permission, I would move to dismiss, but I just wanted to be sure all of that was on the record so that if something were to happen in the future, everybody is aware that those were specifically her wishes.
All right. If that comes through based on all of that, I don't know how you can do anything else. And so I'll sign that. Mr. Franklin, I'm not sure what, if anything, happened. My thought is something did happen. Hang on. Just let me talk. Okay. Don't talk yourself out of this, because here's what can happen. It's not easy, but it is possible to go forward with cases without the complaining witness. So whatever happened needs to not happen again. You need to get a grip on whatever anger, whatever issues you have. If you've got someone here that cares about you and you want to be a part of their life, that's not what you do to people that you love. And it's definitely not what you do where there are children involved. Do you understand? All right, go back with the bailiff. Yes, ma'am.
Okay, another one of these cases where the accusing party retracts. Now, over here, that's really not a possibility. Unless the entire case is completely dependent on that person. Then it's not much they can do. But for instance, in DV cases here, the first thing cops do is take a fuck ton of pictures. Interview, record the interview. Boom, boom, boom. Everything is clear cut, bum, bum, bum. So even if the complaining party or the DV victim later on retracts it for whatever reason, they will still move on with the evidence because they don't need that person anymore. And that is because it's not unusual for victims of DV because, oh, I didn't mean it. Oh, I will be better. Oh, all of that, which is most often bullshit. Yeah, that guy needs to, or girl, yeah, girls too, needs to be in prison. And hopefully during that time, somebody can get to the victim, hey, you deserve better. Because they always do. Nobody deserves to be a victim of DV. Now, if it is a destructive relationship, just walk away, please. And I know it's hard, but please just walk away. I mean, we have here in Sweden, I mean, we don't have many murders here in Sweden. We maybe have in the entirety of the country. Let's see, what's the statistics? Lethal violence. Jesus Christ. We have so stupid statistic always breaks everything down. Yeah, okay. We had last year about somewhere around 30 DV murders. All women were murdered by their spouse. And it is sadly a very common outcome, either complete murder or attempted murder or just kept on beating. So please walk away. You always deserve
Mr.
better.
Parker, you have Tracy Haynes. Good morning. Are you Tracy Haynes? And this is cause number 240514. I'm going to take judicial notice of the court's file. Mr. Haynes was previously found not competent to stand trial and was sent to the John Dunn Behavioral Science Center for competency restoration. I received a packet from them dated June 23rd of 2025 with that report from Dr. Samantha Guzman with the opinion that Mr. Haynes has achieved competency and is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor. No.
Then at this time, I will find Mr. Haynes is competent to stand trial. And will he waive the formal reading of the indictment, Mr. Parker?
Yes, Your Honor.
And are we going on count one only? Hold on, let me get it correct. Yeah. All right, Mr. Haynes, in cause number 240514, the state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of obstruction or retaliation from February 3rd of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please. And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
The stuff on the computer.
The stuff on that computer tablet, did you go over that before you signed it with Mr. Parker?
Yes.
And do you understand those documents that you signed? Speak up, please.
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? So if I follow your agreement, you can't change your mind later. Do you understand?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I have to ask everyone. Speak up, please. When you're answering, I need you to speak up. State tenders number 1.
No objection.
It's admitted. All right, so I'm going to find that you entered your plea of guilty to count 1 freely and voluntarily. Find that you're mentally competent again and that you understand the nature and the consequences of this plea. Find sufficient evidence to find you guilty, and at this time find you guilty of obstruction or retaliation, and sentence you in accordance with your agreement to 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, so you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff.
All right, folks. I've been at it for over 5 hours now. I getting stiff in the back, and I want to say something for tomorrow. But everybody, first of all, thank you. Thank you for being here. Thank you for supporting this channel. Thank you for giving the thumbs up. And for you who can't financially support this channel, go watch my videos. They have a few ads in them. I'm happy with that. I'm happy with that. And if all you can do is subscribe and give a thumbs up, I'm happy with that. Again, if you're struggling, I explicitly forbid you to financially support this channel. I'm such a bad grifter. It's ridiculous. But folks, thank you. Thank you for buying me a coffee, Isabel. Thank you for via PayPal. Thank you so much. Thank you for the gifted memberships. Thank you so much. Thank you for the super sticker and for the treats for Mr. Jingles. Thank you, guys. I deeply, deeply appreciate it. And, oh, wrong one. Wrong. There I am. Again, thank you. And yeah, I will start tomorrow, probably at roughly the same time, 9 a.m. Eastern Standard Time. I will see what I can find for you. I'm missing a hearing from today that should have been today, but I can't find it. Hopefully, I can have it for you tomorrow. But tomorrow is Wednesday. After that stream, I'm traveling up north for my godson's wedding. I will have saved videos from this stream, yesterday's stream, other things that I will post each day, roughly around noon each day. So you will have something to watch. But everybody, thank you so much. Thank you, thank you, thank you. And I will see who I will redirect you to. I will see what that. But I will leave you off with the Free Turtle Boy song. All right. See you in the next stream or video. Have a good one. Bye-bye.
Dr. Turtle Boy walks the line, truth in his hands. Fingers point at shadows, he's breaking their plans. Corrupt suits in the courthouse playing their game. But the lies they sling won't tarnish his name. They try to bury him, but he won't go down. Fighting for justice in every crooked town. Dr. Turtle Boy standing tall in the fight. Truth's his weapon shining through the night. Bogus charges flying, but they can't stick. He's cutting through the darkness, sharp and quick. The gavel pounds, but his voice won't break. No matter how much they take and fake, they try to bury him, but he won't go down. Fighting for justice in every crooked town. Dr. Turtle Boy standing tall in the fight. Truth's his weapon shining through the night. To the edge, but he holds his ground. In the face of their lies, his courage resounds. For every false word, there's a light he ignites. A warrior for truth under courthouse lights. He's been bruised, but he won't lose the war. Kicking down the gates of corruption's door. Dr. Turtle Boy still chasing the sun. The fight's far from over, but he's never done.